Testing, testing. 1, 2, 3.
We are on the record. The Commission will come to order in Administrative Docket PC 55, as well as Rulemaking Docket RM78, regarding retail gas and electric supply offers to low-income customers. We'll begin today by taking appearances of parties that seek to participate actively, beginning with staff.
Your Honor, it's Kenneth Albert on behalf of staff, along with Benjamin Baker.
Thank you. Maryland Office of People's Counsel.
Good morning, Mr. Chairman. Jacob Auslander on behalf of the Maryland Office of People's Counsel, and with me today is Daria Pugh, also from OPC.
Thank you. The retail suppliers.
Yeah, good morning, Chairman, Commissioners. Eric Wallace with the law firm Green Herlocker on behalf of the Retail Energy Supply Association and NRG Energy, Inc.
Thank you. Any other parties wish to make appearances at the podium? Either side.
Good morning, Stacy Rantella, SFE Energy and Statewise Energy.
Good morning, Taylor Beckham here on behalf of the Joint Exelon Utilities, BGE, and PHI.
Good morning, Mark McDougall on behalf of SMECO.
Good morning, Commissioners. Robert Kane on behalf of Washington Gas Light Company, and here with me today is Terry Wall.
Good morning, Commissioner. Laurel Pelletier on behalf of the Energy Supplier Reform Coalition. I can list out all of the members if you need to, but it's a long list. Thank you.
Good morning, Mr. Chairman, Commissioners. Jeffrey Trout on behalf of Potomac Edison.
Good morning, Commissioners. Lauren Molyneux on behalf of the Office of Home Energy Programs.
Thank you to all the participants today. For those of you who are not at the table, if you wish to speak at any point, please approach one of the podiums and we'll move you into the queue. Before we get started with any preliminary matters, Mr. Auslander, I noted that OPC over the course of beginning in May filed a number of pleadings and requests for clarification. Are all of those moot at this point?
Yes, Your Honor. I think that we had hoped that the Commission would choose to implement 4-308 through regulation rather than by order, and we're very glad that the Commission has chosen that path. When we analyzed the statute, we realized that there was a lot more complexity than maybe first appeared, and certainly in the proceedings that we've had with other stakeholders, that has proven to be the case. So we do believe that it's in the public interest to move forward through rulemaking rather than by order.
Thank you. We will deem your motion for clarification moot at this point. Let me begin by saying, as Mr. Auslander just noted, that this is a terribly complex law to implement. I think the law had very good intentions to require supply customers that are on some type of home energy assistance to receive supplies at or below SOS. That's basically what it said. And we have now a voluminous record of how we attempt to implement this beast. We have the Office of Home Energy Programs implicated, the suppliers, of course. We have the utilities participating, notwithstanding the fact that the utilities are only mentioned once in the statute behind a comma in a short clause with respect to a reporting requirement. So it's no surprise that the utilities are questioning why they are participating today. The Commission will do its best to move through the recommendations and the red lines, suggestions of the parties during the balance of the day, but it will be difficult and possibly unpleasant at times. I thank for all those parties that did provide very specific recommendations. Before we roll up our sleeves and proceed in a rulemaking fashion, and I welcome Commissioner Boubart, her first rulemaking session here, there are some threshold questions which I would like to hear some oral argument on. But before we do so, let me just ask the parties if there are any preliminary matters that we should address. Seeing none. The first question, as I alluded to a few moments ago, was the role of OHEP in determining the status of its energy assistance customers and sharing that with the suppliers. Effectively, why are the utilities involved here? There are some claims with respect to privacy, although the statute doesn't respect the privacy of customers who are on energy assistance. And do we need our utilities to serve as the policeman, as Mr. Trout, I believe, stated, or the gatekeeper here? The utilities have reluctantly said we are willing, well, maybe not willing, we will begrudgingly undertake this role if the commission provides them with some hold harmless exceptions. But they also said that this may be very expensive, and the cost will be borne by all utility ratepayers for a program that I haven't seen suppliers lining up to say, I can't wait to sell at or below SOS to low-income customers on energy assistance. In one sense, are we creating this entire function, this whole application process, and no retail suppliers will ever apply? The second half of the law provides the retail supplier prohibition after July 1st for these customers, separate and apart from our application process. So I'd like to hear briefly, maybe we could spend 15 minutes or so on the role of the utility or OHEP in determining these energy assistance status of individuals. Anybody who would like to start? Mr. Trout.
Mr. Chairman, thank you for calling this issue first, because this is my main issue, my main reason for being here. In our written comments, I suggested, just as you did a few moments ago, that the General Assembly was not thinking about the utilities when it passed this law. It was thinking about the conduct of the retail suppliers, and it was putting obligations on the retail suppliers. I also, in my written, I directed your attention to legislative intent as evidenced by what's in and what's not in that statute. Then I directed you to five different practical reasons why using the utilities as the gatekeepers, as opposed to having the suppliers do their own work and getting the information directly from OHEP, was better. Using the utilities as gatekeepers was not the right way to go, and having OHEP give the information directly to the suppliers and have them do their own work, that's better, because you close 3 holes in the program, you eliminate a layer of bureaucracy in which mistakes can be made, and you eliminate an entire layer of cost. Those were the 5 reasons that I advanced. But as I continue to study this law, I came up with another very important point that I'd like to share with you this morning. And I apologize that it's not in my written comments, but I literally just thought of it today. But I think it could be potentially dispositive. The statute says that retail suppliers shall not make offers, except in limited circumstances, to low-income customers. The mechanism that has been designed and that we were going to spend possibly hours trying to fine-tune today has the retail suppliers making offers and then the utilities rejecting them. That's the gatekeeper function that you've been built to us. So I would respectfully suggest that these regs, as written, with the process being suppliers make offers, utilities reject them, violates the plain language of the statute. The only way to comport with the plain language of the statute is for the retail suppliers to not make the offers in the first place, not to have us reject offers that get made. And so for that reason, on top of all the other reasons that I put in our written comments, I believe it would be unlawful, it would be inconsistent with not just the intent, but the plain language of the statute to proceed with these regulations as they've been drafted. And I realize that that puts you all in a very bad position, because you're going to have to take these rules and rewrite them so that the communications are directly between OHEP and the retail suppliers, and the gatekeeper function is fulfilled by the retail suppliers. what comes out of that rewrite will be a lot simpler, will be cheaper to implement, will fill the holes that I pointed out in our written comments, and is likely to be much more effective. But it's from an administrative process standpoint, it's ugly because we're going to have to scrap about half of what we were going to debate today and start over on that half. Some of the things like the applications for offers, the definitions, all of those things, those are still good. But the gatekeeper process, we would have to scrap and start over. And I take no pleasure in suggesting to you that you have a statutory obligation to do exactly that. But that is what I am saying today, and I'm going to take the spears in the chest for saying it, but that's the way it is.
Thank you, Mr. Trout. Questions for Mr. Trout?
I think it's quite clear, but can I just ask, there are some concerns about, privacy concerns, and so what is the practical way then that retail suppliers would know who not to solicit? And I guess I just curious, if we're going to take that particular stance that you're addressing, again, what's your response to that?
All right. There are two possible approaches to that issue, and that's one of the reasons why you have to rethink that part of these regs. One approach is for OHEP to maintain a list and say, these are the people you can't make offers to. And then the suppliers look at that list. The other possible approach is for the suppliers to go to OHEP and say, here's who I intend to make an offer to. Can I make an offer to them or not? Okay? Either way, the retail suppliers are going to find out who the low-income customers are. And there is literally, this is the statute, there is literally no way to implement this law without the retail suppliers finding out who the low-income customers are. So you can't do it otherwise. So those are the two ways. Between OHEP and the retail suppliers, they should decide which they think works better. I have no dog in that fight.
Fair enough. Thank you. Thank you, Mr. Chairman.
I got a question.
Commissioner O'Donnell, then Commissioner Lindsay.
Mr. Trout, are you suggesting that the current draft also creates a conflict of interest between the utility and the supplier for them to make an offer and for the utility to reject it? I mean, we've always had this tension between third-party suppliers and the utilities as it is. Are you suggesting a conflict of interest?
I suggested that in our original filings in PC 55, that you didn't want the utilities interfering in offers that retail suppliers are making. There is an inherent conflict of interest. Now, I will tell you, on behalf of my client, and I'm confident the other utilities in the room, if we're given this job, we will perform it in total good faith.
There's no doubt in my mind
Yeah.
about that. I'm not talking about
But
that. I'm
there
talking
is
about
an-
the inherent
There is
conflict
an
of
inherent
interest.
conflict of interest. That's exactly right.
Okay, I think that's important for everybody to understand, that it's there. You can't do away with it.
If we're the gatekeepers, yes.
Thank you.
So, good morning. I can appreciate the company's concern. It's been a long-standing position that they wanted to have as little engagement between the supplier and customer as possible. But I'm curious if you've thought about the possibility that there might be some need for you to know that the supplier is offering a low-income product and that one of your customers is either eligible for it or not. Is that information that the utilities plan on, or at least consider or propose to be still part of, or are you looking to just be completely out of it?
No, I'm looking to be as completely out of it as the statute allows. There's one piece of information that the statute requires us to report to the commission so that the commission can report it to the General Assembly, and that is offers that get rejected because they were improper. And if you take us out of the mix, then that should be a very small set of offers. It should only be situations where by accident or otherwise, a retail supplier has made an offer, someone, the customer, the utility, the supplier themselves, OHEP, finds out after the fact that they should have not done that, and we do a reject at that time. That's a very small, we can collect that very small subset of information without having to build this apparatus that makes us the gatekeepers.
And so who would you propose to collect that information from?
Whoever's willing to give it to us. No, seriously, that sounds flip, and
No,
I apologize that it does, but that's the truth, Commissioner.
Okay. All right. I may come back with an additional question later, but thank you. That's it for now.
Ms. Beckham.
Good morning, Chairman and Commissioners. Taylor Beckham here on behalf of the Joint Exelon Utilities, BG and PHI. And I do have with me also various representatives from both of the utilities, so they're also available for questions. Not to repeat anything that Mr. Trout has said, because we are pretty much in alignment, and that you, the Chairman, and the Commissioners have noted, but the utilities do have a very limited role within the statute. That role is to report annually to the Commission on the number of customer enrollments that were denied because a supplier was not authorized to serve an energy assistance household. And I think that's pretty clear, as Mr. Trout has discussed. And we're ready to fulfill that role. So one thing I want to just highlight, and as we get this discussion started, and as Mr. Trout touched on, but OHEP should identify the OHEP customers to suppliers. That's not the utility's role, because OHEP is responsible for administering these programs that are at issue. So it's OHEP that has the most recent and most accurate data about who is participating in the OHEP programs. If an OHEP customer switches from one utility to the other, the new utility doesn't know that customer is an OHEP customer. In addition, OHEP is the state agency that's charged with administering energy assistance programs funded with public and ratepayer dollars. So it, again, is appropriate for OHEP to play a role in implementing this legislation. So that's just one key thing that I wanted to make sure that we talked about. Another thing, just to mention, the draft utilities do impose more duties on the utilities than is required by the legislation. And as you noted, those additional duties would require increased efforts and costs by the utilities, which could be substantial. And finally, one thing that the utilities want to make clear is that we should be immune from any liability under the draft regulations if a supplier charges an unauthorized rate to the energy assistance household. So those are the key points that I just wanted to open with. Like I said, I'm here for questions. I have other representatives from BGE and PHI with me. So thank you for the opportunity to give those remarks.
Let me ask Mr. Trout, if you stick around, Mr. McDougall, we'll let you go first, and then I have some questions of the utility representatives. I'm sure Retail Supply would like to respond, and perhaps those at the table.
Good morning, Mr. Chairman, Commissioners. Mark McDougall on behalf of Southern Maryland Electric. I'm standing here to support the comments that Mr. Trout made and Ms. Beckham made. I don't believe Mr. Trout gave the Commission the citation to the statute that he was referring to, that where third-party retail suppliers may not offer to provide electricity. For your information, it's 4-308B1i. And I just wanted to stand and without repeating what Mr. Trout said, support that.
Thank you. Let me ask the three utility representatives right now. Obviously, the utilities right now collect on behalf of the suppliers or the bill, the POR, purchase of receivables. What if the utilities would no longer collect the purchase of receivables for customers that are on home energy assistance? Put that business risk on the backs of the suppliers. This is at the utility election that they're providing this service to suppliers. Is that not true?
So, frankly, purchase of receivables is an area that's fraught with different complexities than this, and some of us in the early days had concerns about us subsidizing the retail suppliers through purchasing their receivables at a discount rate that's calculated in such a manner as to produce, in many instances, a negative discount rate. In other words, the calculation is set up in such a way that we have to zero it out. Otherwise, we would be paying a premium to the suppliers for them giving us the benefit of their bad debt. If what you're asking, Mr. Chairman, is would we feel differently about taking on this obligation if there was an upside to the utilities in the form of being relieved of the associated purchase of receivables. From a purely selfish standpoint, we would have to look at that, but I would suggest to you that the 5 practical problems would still exist, and you'd still have the statutory problem that I pointed out earlier and that Mr. McDougall very helpfully refined for us. I don't think it's lawful to do it this way, and so even if you paid us to do it this way, I think we'd just be breaking the law altogether.
Thank you. Ms. Beckham?
So that's an issue, Mr. Chairman, that is tied up in supplier consolidated billing, and that's one thing that we understand the commission has postponed on that issue because it's so complicated, and there's just a lot more discussion that needs to happen, and we've tried to discuss it, tried to work it out, but it's got a lot of issues in there that we haven't been able to resolve. So that's where we are on that.
Okay, thank you. We'll hear from response. Who at the table would like to speak? Mr. Baker or Mr. Albert?
Mr. Chairman, if I may, I just wanted to say that SMECO is different from the investor-owned utilities in this regard, and that is that we purchase the supplier receivables at 100%. There's no discount.
Thank you for that clarification. Mr. Baker.
Good morning, Chairman.
All right. For utilities who wish to speak, don't be shy. Get in line.
Yeah.
You almost lost your spot, Mr. Kane.
Yeah. I guess I just want to reiterate what my colleagues at the electric company are saying. This regulation is not a good regulation. It's sort of akin to playing telephone, where the utilities don't necessarily have the original information. We don't have the information as to who would receive OHEP. That information comes originally from OHEP. As far as the offerings, which offerings are approved, the company wouldn't have that information either. We could only rely on getting that information from the commission as well as from OHEP, and there could be misunderstandings or miscommunications which could result in probably liability or misdeeds to occur. So that's one of the reasons why Washington Gas is against it. Another reason is because we're still trying to implement SCB, and this would complicate that effort, as well as we're still trying to finish that, and that is why we're against it.
Thank you, Mr. Kane. Staff Counsel.
Thank you, Chairman. This is Ben Baker on behalf of staff. So staff is sympathetic to what the utilities are saying, and we even put in our comments that anything we ask the utilities to do here is going to require time and money, and it's going to be complicated. And I also acknowledge what Mr. Kane just said in terms of there is a timing issue where the utilities are currently trying to set up other programs in the state. In this, we would have to determine, even if we want to go down this road, if we can practically request the utilities to do it by July 1st, 2023. And so that is something that we will need to wrestle with if we want to go down this road. But staff does think this is the appropriate way to go because of practicality reasons. I will first start off, the law does envision some, not to the same extent that was in the proposed regs, but does envision some utility involvement in this, because otherwise the reporting requirement would be a moot point. So there had to be some involvement for that to have made sense. The second is whether the financial liability created by B3 of the regulations is basically indicating that if the offer isn't, the utilities are going, I think to Commissioner Linton's point, the utilities are going to need to know about what customers are low income versus not low income, because if they're buying supplier charges that are above the low income rate, now the question is, okay, well, can the OHEP funds be going to anything above the SOS rate at that time? So I think your POR question was very important in that regard, because financially speaking, we have to figure out, can we redirect or not direct? So how we enforce that is a question that these regs would do, but once again, we are putting the utilities in the gatekeeper role, so that is not to be minimized. Another point I'd bring up is we don't really have any enforceability over OHEP. We can go and tell the suppliers and the utilities to work together, or sorry, the suppliers and OHEP to work together, and there are some existing tools that we could theoretically leverage. I don't know how practical those are, but we could just say figure it out, and if we find out on the back end that you made a mistake, we're going to throw the book at you. And I think that's really our only other choice if we go this way. We don't really have an enforcement mechanism other than a proactive enforcement mechanism. It will be an after-the-fact enforcement mechanism if we don't use the utilities as the gatekeepers, mostly because operationally speaking, we're going to have to find out after the fact if these offers, the utility is going to help filter that. But I do agree with Mr. Trout about the issue of the suppliers really do need to be vetting these customers before they try and set them up in the system, because the law says they shall not make offers. So if the utility is just getting pinged all the time and they're continuing to do rejections, well, that's frankly problematic, and that because that was the supplier's duty at that point. And I would agree, if they had done their job, if they did their job over time vetting these customers, then all these expensive programs that we would build wouldn't really be necessary. But I think from a practical enforcement perspective, over the long term, I'm not sure how we police this area unless we want to set up a group internally who's going to basically be going out constantly to the utilities probably and others to gather data to determine are customers being charged more than they should be.
You raise a very good point there. How do we police this without having the utilities effectively serve as the policemen? I know that the straw does its best to relieve the utility of burdens. I know there's a requirement that best efforts be used by the suppliers to vet these customers who are on energy assistance, but SFE may knock on a door and the customer may not want to share that information. They may not feel comfortable saying I'm on energy assistance. There are some proposals where you need to receive affirmative consent from the customer, and the customer may say, that's none of your business. I'm not giving you consent. Sign me up. And that puts the supplier in a really difficult position. Well, we used best efforts, but we still signed up a customer who may not have been truthful or wanted to cooperate, and now the supplier is facing a penalty of $10,000 per day per violation. Thank you, Mr. Baker.
Can I just...
Mr. Albert.
I'm sorry. May I just ask one question? You did talk a little bit about the reporting requirement, specifically information to be supplied by the utility. I mean, it does say, I think it's Roman 5, the total number of submitted supplier enrollments that were denied because the supplier was not approved to serve energy assistant households, as reported by the utility. Does that potentially imply that there is a gatekeeper responsibility? I mean, otherwise, why would we be going to the utility for that information? And again, there might be just some areas that aren't consistent in the statute, but does that ambiguity require us, though, to consider some role if we were to be successful in collecting that information?
Yes, I mean, that's staff's position has been exactly that. I mean, Now, to the extent that we use the gatekeeping methods that have been set up in these regulations to do it, maybe that's the question the utilities are asking, but I don't think you can get around that responsibility of rejecting an improper enrollment, because otherwise you would just tell us we never had to report anything because we never checked. So I don't know how what the point of that is, unless there was some envisioning of the supplier, of the utilities checking the enrollments. I would also point out, if we get into the operation regulations, a lot of what is proposed there is similar to operations that are envisioned in the supplier consolidated billing arena. Maybe not wholeheartedly in terms of being one-to-one, but when I look through those mechanisms that are there, we're going to have to be building similar gates in the supplier consolidated billing arena. So I do think a lot of this is driven by the liability issue.
Okay, so there could be an intent here, then you're saying that it was presumed that the utility would be the rejector, and so therefore they would be the ones to supply that information to the commission.
I mean, if they're providing us the information, they would have had to reject something.
Okay.
Right.
All right, thank you.
Let me ask the question. Mr. Baker, 4308B2 says, an approved supply offer from a third-party retail supplier shall include a commitment for the entirety of the term of the supply offer to charging at or below the standard offer service rate or gas commodity rate for customers receiving energy assistance. Okay, so that's the kind of the linchpin of this whole thing. Who does staff envision will calculate that? We have proxy pricing built into SOS rates in our auction processes. We have true ups. We have prices changing within the period of a service offer. Who does staff envision does all that calculation?
So this was an issue actually that we discussed in the 2 meetings before we came here to you today, in terms of what is our definition of the standard offer service rate and sales service rate. And everyone was generally in agreement it needs to be an easy to understand value, and it needs to be readily available for the issue of not knowing who's going to do it. Staff has proposed effectively that our interpretation is it needs to be the rate the utility would charge if the customer was with them. So all the variability, all those ups and downs, all those out of period adjustments would be baked in, and we would request that just be posted on the utility's website and wherever they want to put it, but whatever they would charge a customer, but for being with a supplier, that's what we would request to be posted on the website. In terms of over the long term, I think we have to, and there are some of the mechanisms within this regulation give some grace to the suppliers to fix not an undercharge, but an overcharge as long as they do it quickly.
So how do true ups factor into that? Because we're going to have SOS true ups.
Right. And the gas has it once a year at least too through our PG. So those would just be added on top of that rate. So that gets into where staff is simply stating whatever you were going to charge the customer this month for SOS for sales service gas, you would your SOS customers, whatever that rate is, that's what you're going to post because that's what the customer would have paid if they were with you. And so yes, it's going to be a changing value, and the suppliers need to have operations set up to track it. But our proposal is from a just easy sensibility standpoint, just the utilities don't have to transact or anything, just ask them to keep it on their website, and then these suppliers need to be checking that website.
All right. Well, it sounds easy. I'm not so sure in my mind it is, because I know when we have sanctioned third-party suppliers before and we've ordered refunds, that's a complicated process to figure out what those refunds need to be, because it's based on SOS, and you got to go back and recalculate all the fluctuations and undo all of that. So, as the chairman stated, well-intended, get it, but the complexities are huge. They're huge.
Commissioner Bubar?
So, Mr. Baker, under that scenario, how often would those SOS rates change?
Gas, it's going to be once a month at least. The gas charge changes. That's without all the little adjustments. Just gas is our product. The basic product is changing once a month, and that is actually a pain point of this regulation. And staff put forward some regs that try and make it workable. SOS should be more stable because the base underlying charge of it updates once a year, or sorry, not updates every 6 months for residential customers. Don't recall how often maybe some of the minor charges underneath update, and maybe one of the utilities can let us know about that. But that one should not be changing at nearly as often as gas. But gas, it's going to change monthly.
Thank you.
Mr. Albert.
Just 2 quick points. Commissioner O'Donnell, you make the very valid point. We've got a conflict of interest with the utility sort of screening the enrollments by a supplier to ensure, number 1, is that an energy assistance household, and number 2, if so, whether that supplier is authorized to provide that service. I realize it's a concern, but we deal with that by simply requiring utilities in lots of settings to just act in a fair and non-discriminatory way. The thing that comes to mind, of course, is suppliers themselves. If I'm buying off a supplier, the utility is providing me essentially a standalone transportation service, distribution service, I should say. And of course, there's a conflict of interest there because the utility is helping a competitor for the sales service, which involves a margin. And there is a conflict of interest that you're transporting your competitor's supply.
I get that. I do understand that, and I acknowledge what you're saying. But can you give me an example where the utility rejects an offer made by a third-party supplier? That type of inherent conflict?
Yeah, I agree with you. This is an odd position.
I don't know of any other, so you seem to suggest there are many instances.
No, but I'm just simply saying where there's a conflict of interest in terms of what a utility function is.
I get that, but I'm talking about the rejection of said offer and the inherent conflicts built into that specific situation. I don't know of any other scenario that would envision that.
Yes. Commissioner O'Donnell, we are doing that in supplier consolidated billing on a limited basis, but a low-income customer cannot participate in supplier consolidated billing, and if they become one after the fact, they will be dropped from a SCB and possibly the supplier.
Who has the burden there?
So the drop after the fact is on in terms of at enrollment, the burden's on the utility. So the customer cannot be in arrears of more than 30 days. The customer cannot be on a payment plan, and the customer cannot be low income. If they're any one of those 3 at times of enrollment, the utility will reject it.
How about after enrollment?
After enrollment, if the customer becomes low income, the utility will send a transaction to the supplier. The supplier will have 3 days to send a change of contract or a change of bill method to the utility. If they don't do it within 3 days, they're dropped to SOS.
So the utility, other than enrollment, at the enrollment, they're disqualifying the customer, not the offer, right?
Right. So they're not saying that your offer is wrong. They're saying the customer's not available. So.
Right. So we're not really doing that because in this scenario, the utility would be rejecting the third-party supplier's offer. That's different.
Okay, I think you're following what you're saying. Okay.
Ms. Beckham.
And that's really the point. It's just a discrete one that I wanted to make the commission aware of. If the utilities really can't stand in this gatekeeper role for an offer because we don't know the specific offer that's made. We'll only know whether the supplier in general is authorized to make offers to energy assistance households. We won't know whether the specific offer was approved. So that's a key point that I just wanted to highlight for the commission.
Mr. McDougall.
SMECO agrees with Ms. Beckham, but I'd like to throw another wrench into the works here. The statute, as Commissioner O'Donnell mentioned, B2, says that the supply offer from the third-party retail supplier shall include a commitment for the entirety of the term of the supply offer to charging at or below the standard offer service. As Ms. Beckham pointed out, we don't know what the offer that the supplier made to the low-income customer. But one of the differences that SMECO has with the investor-owned utilities is how its standard offer service fluctuates every month based upon its power cost adjustment. So we have a base standard offer service, which is a base standard offer service rate, which is fixed for a period of time. And then we have this purchase cost adjustment, which increases or decreases that base standard offer service rate. And we would find it difficult at best, maybe impossible, to have to monitor the supplier's offers if our total standard offer service rate were to begin to decline as it has in prior years. Because at that point, the supplier very well may be charging a rate higher than our standard offer service rate.
Any others that wish to address this point? I know I stated that I'd like to spend 10 minutes on this. It's been 45, but I think this is a terribly important threshold issue that we need to feel comfortable with before moving on and marking up the regs.
Mr. Chairman, OPC would like to be heard out. Did you want to go first?
You're welcome to go first.
Okay, thank you. I appreciate many of the comments that have been made on this point, but I would like to step back a moment and think about the backdrop against which this statute was passed down in the General Assembly. They were fully aware that this commission has broad authority over the regulated business activities of utilities when they were passing this statute. As Mr. Baker pointed out, there are a number of practical concerns that lead to the conclusion that utilities are going to need to play a very important role in the implementation of the statute. And the reason is because as part of their regulated business activities, they are in receipt on an ongoing basis of the two key pieces of information that we need to know in order to implement the statute. One, the status of a customer as an energy assistance household. And two, whether that supplier is being served by, whether that customer is being served by a supplier. I think that some of the concerns about the liability that the utility would face, or the level of oversight that their screening processes would need to impose, are the subject of discussion today. I do agree with Mr. Baker's point on the practicality that we would prefer that we implement this statute in a way that can be automated by the utilities, that would have the utilities play a very ministerial role of checking, the status of particular enrollments, and not invoke maybe the sort of business decisions that would lead to the conflict of interest concerns that you brought up, Commissioner O'Donnell. So I think that if we did not pursue a path that would see the utilities play an important role, I think that we almost would need to go back to the drawing board in a way with these regulations. And I note that the statute does have deadlines for implementation. The substantive portions of this statute are going to go into effect next summer. So I think that there are a number of decisions that the General Assembly has entrusted to this commission, and I think that what has been proposed here in these draft regulations, by and large, are within the commission's authority to pursue, and will implement the legislative intent to have energy assistance customers pay no more than the utility's standard offer service rate for electricity or sales service rate for gas.
Thank you. I think the intent was clear. The role of the utilities, I sympathize with the argument you and Mr. Baker said. Mr. Trout was very persuasive out of the box, stating that this is unlawful and the legislation is less than clear with respect to the role of the utility. We could surmise that the utility, they're the trusted ones right now with this OHEP information. They do have flags on these accounts, I would say these service addresses, where the residents are qualified for home energy assistance. But I think it is a bridge to place the utilities in that role. And I'm struggling, as many of you are, with the fact that we're dealing with a piece of legislation that is not the model of clarity here. We're having to make some pretty big leaps of faith. And Mr. Auslander, let me ask you this. The utilities said if ordered to do it, they'll be good soldiers and they'll do it. There's going to be a price to pay. Are you comfortable, as the state ratepayer advocate, that we're willing to pay that price?
So I do think that there will be a number of changes to their IT systems, for example, that will need to be made. That those costs will be required as far as the position that we're advocating by commission order by passing these regulations. We note that, as Mr. Baker alluded to a little earlier, many of the systems and functionality that we would be talking about are going to be put in place through the implementation of supplier consolidated billing. There will be a much more complex process that utilities are going to need to implement to move forward on that initiative. To the we are not simply building these systems just to implement for 308. There will be systems in place that will, as Mr. Baker alluded to, allow the utilities and supplier consolidated billers to check the status of customers at various points in time. So we would, of course, want to reserve our right to analyze the costs that the utilities are claiming are needed to implement. To date, we have seen no estimates from utilities as far as the cost of implementing 4308. But having said that, we understand that there would be costs, and that those costs would be the type of costs that utilities have traditionally been able to recover through rates.
Based on my experience, the utilities will start at $1 million for all of these costs, regardless. Commissioner O'Donnell.
And just to follow up, because I appreciate the chairman asking the cost question, because I was going to ask you the same thing, but you're not suggesting that these are one-time IT costs, because I believe there's going to be ongoing costs that continue to get passed on to and socialized across all rate classes in the state.
Yeah, I am not an IT expert. I would imagine that there are probably some upfront costs, and then there would be ongoing maintenance costs.
Well, not just maintenance, but you heard my discussion about the calculation of SOS and the fluctuations of SOS, and someone's got to monitor that and compare it to the offers, and there's going to be a lot of costs associated with this on an ongoing basis. If you're wealthy, it may not bother you, but if you're not wealthy in this environment, you're worried about whether or not you're going to have electricity or whether or not you're going to buy as much food as you had.
Right. Well, and I think that certainly the intent of 4308 is to make sure that vulnerable families that are on energy assistance are able to afford those necessities and not be faced with the prospect of paying energy rates that are in excess of the utilities default rates.
I get that, but I'm talking about the people who are not on energy assistance, but who are marginal, who are going to have to pick up these costs.
Sure, and my without having the cost estimates in front of me, I guess I can only surmise. I would imagine that these costs are not at the level of the AMI meter deployment, for example, or other very expensive initiatives that the utilities have pursued and that the Commission has approved.
This question might be for Mr. Baker. I'm not as familiar with where things are in the SCB process as maybe I should be, but would we be precluding options for where we're going to end up in SCB by making decisions?
We should not. I'm trying to think. What are you? I guess you have any examples of things you might be worried?
No, I'm just wondering in terms of the logistics or kind of the IT requirements.
SCB is currently our goal. Is December next year. I think it's fair to state that we are a little worried about hitting that date with implementation. There's some in this room who think we should be pushing it further. There's some who that's still their goal, and so we're going to have another discussion about it actually soon in the work groups. But we are currently striving for next December is the goal of that. But there is some possibility that that's going to slip into 2024, and so any systems that I am talking to you about that are similar to SCB, and I think this is what Washington Gas might have been getting to if Mr. Kane wants to weigh in more. But I think any systems we build in SCB that we think we could leverage here, it'd be probably more efficient. Maybe, the utilities can weigh in. Sometimes they're saying it's not a good idea to stack things on top of each other. So I'm not going to pretend to know how they want to definitely build it, but some of these systems would likely not be in place until then. We could ask them to do it faster, but there's going to be a cost, and I don't know how practical that is. And I would guess I would look to the utilities to know what they think is reasonable. So that is, from an operational perspective, something that we would have to consider, and if we would need an interim solution until, if we were going to try and be flexible on the dates, that we would ask the utilities to be ready to play the roles that we have in these regs.
Thank you.
Mr. McDougall, sit tight. We haven't heard from the suppliers yet, so let's hear from the suppliers now. Mr. Wallace.
Yeah, good morning. RISA and NRG in our comments, we've taken an approach to this implementation that's really been focused on, implementing the requirements of the statute as efficiently and effectively as possible so that we can have a successful transition next summer when these statutory requirements kick in. And in fashioning our comments in this proceeding, particularly in our July comments, we attached an order from Pennsylvania, where the first energy utilities up there implemented a similar program, and it laid out the roles of the utilities and the suppliers in implementing that, and certainly both are involved. When you boil it down to what's in the statute, certainly there is a requirement that the utilities have a mechanism in place to accept or reject enrollments based on energy assistance status and the approved offer, and then report on that. Right, so in order to be able to report on that, they have to have that mechanism in place. That is the same kind of mechanism that the utilities in Pennsylvania have implemented, where my understanding is that when a supplier submits an offer, they identify it as a eligible energy assistance offer or not, and then the utility, when it receives that offer, it then checks it against its records to see if that's an energy assistance customer or not. If it clears, it goes through. If it doesn't, it gets rejected, and a reason code goes back to the supplier to let them know what happened. And that happens at the back end of the process. At the front end, suppliers also need to have information to be able to, determine whether or not a customer is an energy assistance customer to avoid submitting enrollments. I think to Mr. Trout's concern, the suppliers need to be able to have mechanisms in place to mitigate the amount of enrollments that might be submitted for energy assistance customers. Sitting here today, and historically, suppliers don't know which customers are on energy assistance. They don't know which of their current customers are on energy assistance. They don't know which prospective customers are on energy assistance. So, in order for suppliers to be able to, determine the appropriate offers for customers, they need to know that energy assistance status. And there's a number of ways that that's done in the Pennsylvania program. One is through a list of eligible customers that the suppliers can use for the customers that are new customers that they're marketing to, but then they also get data from the utilities that identify which of their current customers, especially as part of the transition, which of their current customers are on energy assistance. And so there's a number of different ways that this information can and should be conveyed to suppliers. But there's definitely a role for the utilities to play here and for the suppliers to play here. One kind of key issue that we see generally in the rules here, and one kind of limitation on the utilities' role that's important is, we don't agree with the rules that would contemplate that on an ongoing basis, the utility would cancel existing enrollments for suppliers. Right? Suppliers should be notified if a customer goes on to energy assistance, and then follow the appropriate procedures to notify that customer at the end of their contract term, and then to drop that customer or transition them over to an approved offer at the end of their contract term, consistent with Section B2, little 2 of the statute. But really the utilities' role should be in accepting or rejecting the offers based on the qualifying information that's provided at the time of enrollment, and then providing the information to suppliers about their existing customer base.
And Mr. Wallace, you just explained sort of the role that the utility would have to play as you envision it, and it's rather active. The utilities say that there will be a cost. The utilities also say that the retail suppliers should pay their cost. If not, then the retail ratepayers who should pay the cost of the utilities here? Ratepayers or the suppliers?
Yeah, so the suppliers are going to have costs to implement this as well, and they're going to be paying for those costs. In Pennsylvania, my understanding was that the utilities recovered their costs through their distribution rates to implement this program, and we think that's the appropriate cost recovery mechanism here as well. And in the big picture, I mean, there are competing goals here of it within the public utilities article of developing and promoting retail choice, and also implementing this statute, which has a limitation on retail choice, but to do it in a way that that allows the competitive market to continue to progress. And so there are competing interests here.
How is the market competitive if the legislature has, by statute, stated that your suppliers, your members, going forward have to sell at or below SROS? Is that a real profit center? Is it a business opportunity to be selling to customers on home energy assistance? I can't imagine your members were really thrilled when this bill was signed by the governor.
Yeah, I don't know the extent to which suppliers will be able to make these offers.
Exactly, and that's my concern here.
The standard offer service rates change over time. The market fluctuates over time, so it will depend upon how the wholesale market and the SOS prices align over time. But
fair to say your members are more concerned with the July 1st prohibition date and not crossing with the law on that.
I think that's the focus of our comments. And when I talk about the maintaining and kind of protecting the competitive market going forward, I mean, all suppliers, whether you have an approved offer or not, are going to have to take steps to implement this, the requirements that prohibit enrolling customers in energy assistance. And they're going to have, there's a lot of work that's going to be needed done to implement that, even if you do not have an approved offer. And so that's an important piece to keep in mind, is that this affects all suppliers, whether you're making that specific offer or not.
I suspect the commissioners will have some questions of you, Mr. Wallace, and I know we're already 1 hour into this, and we haven't even reached threshold question number 2. I don't want to rush this discussion today because it is important. I also respect the General Assembly and the law that we have on the books that we do need to do something. But the fact that, as Mr. Trout said, and I am somewhat sympathetic that we're wading into unquestionably unlawful waters here, does weigh on me. I'll turn to my colleagues for questions for Mr. Wallace, and then the utilities are lined up again. Commissioner O'Donnell.
Thank you, Mr. Chairman. Mr. Wallace, how do your suppliers view their offers with the kind of add-on goodies, the microwave oven or the toaster or the blender or the 1,000 miles for signing up? How is that calculated into the offer? How do you account for all those goodies in your members' offers?
So how does an individual supplier factor the cost of incentives?
I'll say it this way: how are the utilities supposed to figure out what value to give to that to make sure that you're staying under the SOS threshold?
I don't think that. I mean, and if there's someone else in the room who's more familiar, I don't believe that the incentives associated with an offer are factored in as a credit with respect to a supply rate in Pennsylvania, for example. I think it's a pure commodity rate comparison.
Okay, so that makes it less complicated, but somebody has to pay for that. Are you guys giving that stuff away out of the goodness of your heart, or what? I don't get it.
I think that there are a number of different marketing and incentive costs that are built into a supplier's cost of doing business. So if they are offering an incentive along with a commodity price for an approved offer, I don't think that you can factor in the incentive as part of that.
I don't think so either. But when and if we make these regs, I want to make sure I understand it. So that's why I asked you the question. Thank you.
Do you have any information from Pennsylvania on what the uptake rate was, or suppliers in terms of being interested in doing this kind of business?
it's a great question. I don't have specific metrics. The general, I was reading about it last week, and the general trend I think that we saw was that, there was some initial interest, and it has waned over time as it's been harder and harder to meet or beat the SOS rates in Pennsylvania. So I think there's some participation, not a lot, and as markets shift, those offers kind of come and go as well.
Anything different from New York?
Not that I know of.
Thank you.
Mr. McDougall.
Thank you, Mr. Chairman. I initially rose when the discussion of costs came up, and I agree with Commissioner O'Donnell that there not only will be initial costs, but there will be costs that are incurred year over year. I don't know what they are as I stand here right now, but I did want to address the comments made by numerous panelists that the utilities have been involved with supplier coordinated billing and will be adjusting their IT systems to comply with the requirements of SCB. I wanted to remind the Commission, because we've talked about this before, that Public Utilities Article 7-511A exempts cooperatives and municipalities from supplier coordinated billing. So we are not involved with the SCB work group and in the process of considering changing our information systems to comply with that. So if we're talking about costs, that would be additional costs that the cooperatives would have to undertake if we were going to be complying with any regulations that required that. So, we are. I just wanted to throw that out there as an additional cost that we would have to incur.
Thank you, Mr. Trout.
3 points. They're all factual and related to the discussion that the Commission has been having with the other panelists over the last few minutes. I do not have a cost estimate, and the reason I don't have a cost estimate is that our people are still trying to figure out how we would do this, because this is different and more complicated than what was done in Pennsylvania, and it's different and more complicated than what would be done for SCB, and I'll come back to that in a minute, very much related to my second point. But what we do know now, or at least our best estimate now, is we can't do this. We certainly can't build an automated version of this by July 1. That's just a fact. And, we can't start design until we know what, at least there's been a set of draft regulations that has been approved by the Commission and has gone to Annapolis. I mean, in theory, we shouldn't start until it comes back to you and is approved. But as a practical matter, until you vote on something that you're willing to send to Annapolis, we can't start building. But even taking what we have and trying to scope it out, we are confident we can't do it by July 1. So it wouldn't be automated. That's the first point. The second point is, and this is an argument I get into in the work group meetings all the time, and I'm sorry to export it into this room, but it needs to be said. IT system changes are not simply additive, and they usually don't overlap. What happens is every time you have a different change, you have to test it against everything else in the system to make sure nothing is going to blow up. And when you're trying to make 5 different changes to the system at one time, adding a 6th doesn't increase the work by 1. It increases the work at least 6 times, because then you have to go back and test it against the other 5. I don't know if that's an algebraic relationship or a geometric relationship, but it's not a straight relation. It's not a straight additive relationship. So the more we try to change, the more complicated it gets, and the more likely you are to break something important. And that becomes particularly true with respect to this, because it's not correct that what we are apparently going to have to do for SCB is the same as what we would be asked to do in these draft regulations. In SCB, there will be more or less a bright line. If you're low income, you're on a payment plan, you have arrearages of a certain amount, any of those things, you're out of SCB. It's a more or less bright line. It's not going to be easy to do that, but it's a lot easier than you're low income, and then we have to figure out whether it's a qualified offer or not, and then we have to monitor the entire duration of the contract to make sure that at no point during the duration of the contract does the price being paid under the contract slip above SOS price. That's way more complicated to do. There is not going to be anything that we can leverage from the more or less straightforward tests. I'm amazed that I'm using the word straightforward and SCB in the same sentence, but the relatively more straightforward tests we have to implement for SCB as compared to what these regulations would ask us to do. And then my third and final point is with respect to Pennsylvania. I really had tried to get someone here today who could speak to you about our affiliates' experiences in Pennsylvania. And if we come back to another day and another hearing on another version of these regulations, I promise to do my level best to do that. I just couldn't do it today. But what my understanding is with the state of play in Pennsylvania is that the idea of qualified offers just hasn't worked, and that the final version of the last set of tariffs that our affiliate in Pennsylvania filed, or the most recent filing by one of our affiliates in Pennsylvania, is a bright line that you don't make offers. Retail suppliers don't make offers to low-income customers, full stop. So the statutory scheme in Maryland, which is to allow qualified offers, to the extent they tried to do something similar in Pennsylvania, it just hasn't worked, and it's become a bright line. As a practical matter, it's become a bright line. If the customer's low income, they're not getting offers, full stop. So those are the additional facts I wanted to put in front of you this morning.
Thank you, Mr. Trout. Let me ask Senior Commission Advisor Molly Knoll. Ms. Knoll, does the Commission have the ability or authority to go along the lines of what Mr. Trout said, and I'd like to hear from Mr. Wallace, and just simply make life easy for everybody involved? I'm
stealing Mr. Baker's statute book real quick.
That the Commission go further than the statute, do away with the at or below SOS, and simply implement a prohibition that restricts suppliers from making any type of offer to a customer on low-income energy assistance.
So the statute requires that the Commission establish a process to approve offers. The Commission could make that process inordinately difficult to achieve, but I believe that the statute contemplates that offers should be available in the market.
So the legislature wants folks on home energy assistance to continue to exercise retail choice, but only if they get a good deal.
Correct. And Your Honor, I would point out that 4308B3 really, and it hasn't been mentioned much this morning, gets to the heart of the protection that the legislature was going to, which is that OHEP funds, public dollars, should not flow to these contracts in excess of SOS. So that section, B3, does not refer to offers. It refers to charges that suppliers can make to customers and monies that suppliers can receive. And the way things are set up in Maryland, the backdrop against which the legislature considered this is that the monies flow through the utility.
And I think that is the driving intent of the legislature, to make sure that home energy assistance dollars are not paid in excess of SOS. My thought was, if possible, just effectively outlaw retail supply by regulation to these customers. I don't know where the legislature, I'm trying to divine their intent through this mismatch of 4308 that they put together. And we've now spent going on 2 hours, still on the first threshold question. So thank you, Ms. Knoll.
I just want to clarify one additional point. I'm doing my level best not to argue anything while we are here today, but I do want to clarify one statement that Mr. Trout made, which is that these strawman regulations and the edits from all of the parties do not create any obligation for the utility to provide ongoing monitoring of what is actually charged to the customer. There is an initial review of whether the supplier is on OHEP and the supplier has a qualifying offer approved. There is no obligation for the utility to check what actually appears on the customer bill versus what the supplier is actually contracting for. That obligation does not exist now, and it would not exist under any of the edits that are proposed before you today.
Thank you.
Let me ask you about that, if I might. What if the offer is a variable rate offer and it goes through the roof? How does that change what you just said?
It would not. The utility will still pass through the charges exactly as the supplier places them onto the bill as far as the utility role is concerned. The way the straw man is structured is that then there is an enforcement provision where if a customer has a complaint, they will come to CAD the way they normally do. If there's an investigation by staff or by CAD, it'll come to the commission the way it normally does. And then there's a remedy outlined in the regulations.
Yeah, but it clearly, if you're on a variable rate, there are weather conditions that could be created or other market conditions that could be created that could send that way north of SOS.
So I would foresee that the commission would not approve a variable rate in a low-income offer unless there was a limitation in, when the commission considers whether or not the offer can be made, the commission will check that offer against the terms of the statute.
And Commissioner O'Donnell, some of the proposed rules in these COMARs effectively envisions if there is a variable rate of any sort, or if at any point SOS drops below a fixed rate, the supplier is going to have to modify what it is charging that customer to drop it down to meet that SOS. So it's
But
almost.
if they have a contract, how do we mandate
I
that
think
in
it would
reg?
effectively, because we're approving the offers before, or we're reviewing before they make an offer, so we could conceivably, when we're reviewing an offer, ensure that there's a contract term in that offer that effectively states at any point that the SOS drops below the rate I have here, you will be assessed you'll be assessed the lower of the two rates. So, I mean, they all in my mind, they actually all effectively are variable rate contracts, but in the downward. That's the only way we could conceivably set this program up and meet the intent of the statute, because, to your point, the rates are, especially for gas, but also for electric, are going to always be changing. And so the only way we can do that is the suppliers are going to have to be able to modify their rates charged to customers on the fly and bring them down if at any point that there's a drop in SOS.
That's another, in my mind, another argument as to why this will never be done by suppliers, I think.
And then, Mr. Chairman, to your question about outlawing choice, I don't know if I would point out, not on that issue, but we could go for financial remedies here, where we are opening up how we treat supply. If we don't want to go the full way of saying, well, we're not going to outlaw a choice, but we could say we're not going to purchase energy assistance receivables from those who we know are eligible. We could go back to a pro rata for any of those. Our COMARs are currently set up where it's dealer's choice from the utilities if they purchase receivables or not. That will be a programming change. So once again, we're still messing with the utility systems and programs. But if we don't want to go as far as outlawing, we could at least basically set it up such that the state and the utility is never really responsible for ensuring payment of those of supplier charges that are dealing with OHEP funds.
Thank you. I think the law has already made this so unpalatable for the utilities that we could go the step further and greenlight the utilities to stop collecting the POR, put that business risk, that financial risk on the suppliers, and they won't be touching these potential customers with 10-foot pole. Ms. Ferrantala, you've been waiting patiently, and then Ms. Peltier.
Thank you. I just wanted to punctuate a few points that I thought were important, and I think, everyone that's spoken so far has advocated for minimizing the utility role, and we agree with that, but there are certain facts that we have to deal with, which is that suppliers don't know the customer's energy assistance payment status at the initiation of the enrollment. So clearly we need some sort of tool in order to be able to comply. The utilities do know the status, and suppliers have systems set up to transact with the utilities right now to exchange information. We don't have those sort of systems in place with OHEP. We agree that the utilities should not be the enforcers, or I guess the word we've been using is gatekeepers. Our comments were aimed at the utilities providing a transactional role, a mechanized process, as some people have talked about. So there wouldn't be subjectivity, there wouldn't be utility monitoring. In our view, the mechanized process would include providing the suppliers with the list or the identifier so that they can pre-screen the customers so that we're not submitting offers to the utility. The utility rejection would be a secondary measure to catch an inadvertent enrollment.
Ms. Ferrantala, I agree with everything you said, although we've heard from some saying, well, the supplier should not receive the identities of who's on home energy assistance. So that does hamstring you a bit if the commission agrees that these privacy concerns are legitimate. Is that true?
I guess I find it hard to believe that the legislature would pass a law that said suppliers can't serve these customers, but
Bingo,
then
yeah.
prohibit us from having a mechanism to identify them in some way. And there may be a way to do it that minimizes the privacy concerns, and I guess that's sort of one of the other issues to discuss.
OPC, Montgomery County, and others, I think, will vehemently disagree that you can't call Director Molyneux at OHEP and say, give me all of the people that are on welfare, public assistance, home energy assistance, using public dollars or ratepayer dollars. And there are legitimate privacy concerns there. But there's also a statute now that says you need to know who you could sell to. And you can't go knocking on doors and not know you don't want to violate the law. None of the retail suppliers want to knowingly violate the law. So it is a bit of a catch-22.
And also mindful that there were some commenters that said, well, suppliers just don't sell to those neighborhoods that typically are of a different economic status. But we also have commission regulations that prohibit redlining. So suppliers actually can't do that. That's prohibited behavior. So speculating about whether a particular neighborhood should not be marketed in, it is not allowed. So
that's discriminatory.
Exactly.
Thank you, Ms. Rantala. Commissioner Bubar.
Can you provide any insight on what kind of transactional costs the suppliers would have in terms of keeping track of when the SOS rate might have changed and when they may have to change their contracts? How do you keep track of all that? Are your systems set up to do that now?
That's not a question that I know the answer to. Not a transactional expert.
Okay, thank you.
Ms. Peltier.
Good morning, Commissioner and Commissioners. I wanted to add a backdrop. First, I wanted to share that in 2020, the law that came out of ECM right before COVID was a full ban on OHEP accounts. It was passed out of ECM, and it was passed out of the House, and it arrived in the Senate on the day that we all closed down. So I just wanted to put that in perspective. I also we feel that we have an obligation to be the voice of a lot of consumers. And I very much appreciate that this is going to cost money. But this has cost residential consumers $1 billion more. On top of all that, as retail choice was enacted, as it was put into place, as POR and utility consolidated billing were put in place, as SCB was put in place, as RM54 was put in place. I hope the utilities complained about paying for it, but the ratepayers paid all those expenses to make retail choice work, to allow a competitive market to start working. And I have two pieces of paper that I can either give to you guys now, Ms. Bouchard, welcome, or I can leave that show why this law came around. Last year alone, in 2021, residential electricity payers paid $117 more. And there was one supplier that did charge SOS rates. The largest supplier did. The balance, the other 41, charged 48% more for electricity. And you will be able to see the actual rates. And you can actually see the ones that go into the low-income areas. They're paying $850 more a year. That is almost double their entire, that's about 50% of their bills. That's why we're here. And I have historical rates back to 2013 showing that the rates have always been substantially higher. And the ratepayers not only picked up the costs of making that happen at the utilities, because the utilities do all the billing, but the ratepayers picked up all the POR, I can verify 100% the $630 million in electricity per federal data. And so I can also verify per year reporting where they sell. And this is very important for everyone to look. They sell in our 10 lowest income zip codes. You want to go down with me to the Northeast market? And we can get the alpha rep there. I could tell you where everyone's selling. They're selling in the very lowest income zip codes. It is disproportionately hitting low income zip codes. You can see the rates.
Thank you, Ms. Peltier. I don't mean to interrupt.
No,
but
I just appreciate, I just wanted to say that the customer, all of us are paying for this. And I think we should be as responsible. I mean, you're the commission. This has been 6 years now. This is taxpayer money just paying these bills. And they're not just like $50 for a Google. They're huge. So thank you. I would be happy to answer any questions. So
Thank you. And we cannot accept any documents now, but if you'd like, you could put them in the formal record.
You got it.
In RM78. Commissioner O'Donnell, you had a question?
Just to clarify, would you support an outright ban?
I think it would be the easiest way for our state to implement this. It would be the easiest for the utilities. It would be the easiest for everybody.
Thank you.
Commissioner Linton.
Thank you, Mr. Chairman. Ms. Peltier, not yet.
Thank
Just
you.
a quick question for you. Since you're here, and as you stated in your testimony, you've had the opportunity to interact with consumers on a
Direct basis.
directly basis.
Every week.
We've had some discussion here today about concerns about consumer privacy and providing information from consumers who are participants in our energy assistance programs to third-party suppliers. What is your thought on that?
I appreciate that, and I know that there is a tool right now that everybody can use called My OHEP Status, and very quickly beep right into it. And if somebody would give their last name, the last four of their social, and their birth date, which is their choice, you can go right into My OHEP Status and see if somebody's on energy assistance.
So you wouldn't have a concern about third-party suppliers accessing that information?
I think it is reasonable to do our very best to keep OHEP households paying rates. We are taking taxpayer money to make their bills more affordable. And the last thing it seems like our state would remotely support is making them more expensive. So I think there's some very clever ways. Maybe there's an anonymous, maybe there's just a red check that comes up next to the EDI file when they go out there. Because I know I watch these guys, they sell. Maybe there's just a red star. Maybe there's just something that symbolizes, you put in the address, because they go up and they put the address in, and it may be just something that pops up and says move on.
without sharing information about age and social security number and
Right.
income and things.
And that's what's available now, and that's where the prospect would actually give, and because you're in a sale over buying this energy product. So I think a lot of this is easier to do than we're making it out to be. Just pick one SOS rate for the month, keep it. One gas rate and keep it. This is this is causing turnoffs, and this is causing massive arrearages.
Different utilities have different rates. We can't just pick one.
For each utility, well, right now, I mean, each of these suppliers has multiple. They change their prices daily. They have entire teams that sit there and do all this pricing.
I misunderstood you. What
You're
you
right,
said.
so-
Just pick one.
You're right. That wasn't clear. Pick one for the month for the utility. Look, I'm going to tell you, when you look at these rates, that would be ideal. When a customer comes in, I could talk about this for a long time, and has an extra $1,000 on their bill, not even knowing who a supplier is, even close to SOS and close to gas commodity rates would be ideal. These rates are significantly higher for low-income households than they are for non-low-income households. And you'll see that. Actually, the wealthier households are saving. They're getting a gift card and they're getting SOS, not the low income. So I appreciate this time, and everybody, the cheapest way possible, keep these accounts off this. This is not where our tax dollars and all this time and effort and PC 53 and going to OHEP and all this federal money, it is being wasted across the board.
Thank you,
because it's not working. Thank you so much.
Thank you. Mr. Wallace, Ms. Peltier just mentioned the My OHEP portal, My OHEP access portal. I understand from some of the comments from perhaps RISA or SFE and Statewise that they don't want to check one at a time. They want an automated process through the utility. Are you aware of the portal? Have you tried it? Is it that cumbersome where the suppliers do not want to go one at a time, putting in date, social, whatever else information you need?
Yeah, so that it's a one lookup at a time tool where you have to put in that information for each individual customer, and to make the market operate, I mean, we need to. It's important that systems be automated and be able to do on a batch basis, and so having a requirement that for every single enrollment, to have somebody go in to that website, get the information from the customer, the last four of their social, plug that information in, see what information comes back. If the data matches up, you might get a hit. If the data doesn't match up, you might not get a hit. That's not a practical way to screen all of your enrollments for customers going forward across the entire state. So we're looking for tools that'll make this an efficient process. Things like batch lists, EDI XML transactions where you're getting information back when you're submitting enrollments, or you're getting lists of your current customers back that you can match against your current customers. And another,
it does make the life of the suppliers easier to have all this XML communication. But at point of sale, if you have a salesperson, let's say a door-to-door, or even responding via online, that information could be collected at point of sale at application. And is that really that much of a burden for the suppliers?
I think it is. I mean, I think because you're going to need the customer to provide information that they don't currently provide, right? They need to provide their social as well. And then you have this additional step that you're adding to the process where on an individualized basis, you have somebody in the back office or in the field going in and plugging that information in for each individual customer. It's a manual process that is going to be, expensive to implement. It's going to be, it's not an effective way to do this. And it also, another thing that I'm thinking about is that, at the end of the day, it's also important that the data sets match up, right? So OHEP is providing a list of customer accounts to the utilities. The utilities are matching that information against their information and their account numbers and so forth. and then on the back end, and if they can provide that information to suppliers, then everybody will be operating off the same data set.
No, you've made that point, Mr. Wallace. Thank you. Counsel, if you could make an appearance.
Hi, excuse me, Garrett Fitzgerald with Montgomery County. I just want to come back to two quick things. So we believe the intent, this is clearly consumer protection legislation that was passed, right? We believe the intent is that it applies to everyone on OHEP, and that it's erroneous to read into this that it should only apply to new offers made after July 1, 2020.
Well, we haven't reached that argument yet.
No, so I'm just coming back to there was a statements that Mr. Trout made and Ms. Knoll made. We suggested that we do think it should actually apply to existing contracts. And so what Mr. Trout said earlier related to what all the utilities would be required to track to be able to implement the legislation, which included being able to monitor on an ongoing basis the charges that are charged to customers. And Ms. Knoll suggested in the regulations, the current version of the regulations, draft regulations, does not suggest that would be happening. We think that will need to be happening, because without actual verification and monitoring and enforcement, it's left to just the customer to ultimately make a complaint, which is...
Ms. Knoll was making reference to the statute. The statute doesn't envision. Is that correct, Ms. Knoll? Or were you saying the regulations?
As drafted, the regulations do not put that monitoring role on the utilities. Should the commission decide that that's appropriate, the statute or the regulations can be redrafted to accomplish that.
And you're saying customers should not bear any... To date, nothing in here puts any burden on the customers.
So the whole reason that this legislation needed to be introduced and passed at the General Assembly is that we need to do protection for these customers, right? These customers, we all know it's not a rational choice on behalf of these customers to sign these contracts that result in the kinds of economic impacts that Ms. Peltier just summarized for us. That's why consumer protection legislation exists. By the same logic, the regulations themselves should not end up placing burden on the customers to notice that they are being price gouged by these retailers. The regulations themselves, if we're going to actually adopt regulations to prevent this, the regulations to be effective should have an enforcement mechanism where we make sure that it doesn't actually end up happening anyways. And I want to the last thing is just to agree with Mr. Trout. I think all the things that he summarized, very sympathetic to the utilities that would need to be tracked, will need to be tracked. This is all real. And ultimately, the choice that we face is, do the utilities play the role that's proposed in the regulations? And if not, what's the alternative? It's hard to imagine an alternative that doesn't involve all of that being done in-house at the PSC with data that would mostly have to be reported partly from OHEP, but also from the utilities to be the magnitude of the work involved to enforce the regulations doesn't really change regardless of who's playing what role, and the costs that will ultimately be borne to enable all of that work doesn't really change. So it's tough. It's going to be very difficult to do this, but we do believe that the intent of the legislation is very, very important, and just support the commission taking this very seriously and ultimately doing what needs to be done to enforce it properly.
Mr. Fitzgerald, what's your title with the county?
I am the State Climate and Energy Policy Manager with Montgomery County.
Thank you.
At this time, before we move on to the next issue, do commissioners have any additional questions of any of the parties? Seeing none. Well, oh, I'm sorry, Commissioner Linton. I always lose you there.
I'm debating if I want to raise it now or not. Okay. Because I said I was going to ask an additional question of the utilities. And I was hopeful, actually, Mr. Trout, since you seem to be the council, you actually raised a point. I figure I'll ask you. Thank you, Mr. Chairman. I know we'd like to move on, but Mr. Baker raised a point that I was hoping you could respond to regarding the Commission's authority to direct another state agency to release consumer information. I just wanted to get your response to that. Just, do you think the Commission has the authority to do that?
I don't. The short answer is no. The longer answer is no, but you do approve their budget. And so if in the course of reviewing their budget, they didn't say something along the lines of, and we're doing this for you too, you would have the ability to say something about that. And the other thing is that I have every expectation that OHEP would be willing to do whatever was reasonable. And it's really a question of what's the most efficient way of getting the information from OHEP to the suppliers. Is it the suppliers talking to OHEP, or is it OHEP talking to the suppliers? Because the one thing that's clearly not efficient is OHEP talks to the utilities, and then the utilities talk to the suppliers. You've just inserted an unnecessary additional step.
Okay, so I've thought that everybody knows that the commission has oversight authority over the EUSP program. But as you know, we don't have the same authority over the LIHEAP program.
Correct.
So that's, according to the statute and the way it's drafted, it just references programs, energy programs administered by OHEP, which includes LIHEAP. So does your position still remain the same? I can see where there could be an argument over EUSP. But what about for the consumers that are accepting LIHEAP money only?
Yeah, to be clear, Commissioner, my position, either the short or the long version, is you cannot order them to do this. My suggestion was that they will do what is needed if you ask them to, especially since you control their budget.
For EUSP?
For EUSP.
Right, okay. All right, thank you. That's all I have, Mr. Chair.
I was going to move on, but I see Director Molyneux smiling a bit in response to Mr. Trout. Ms. Molyneux, we have not heard from you, and I hate to put you on the spot. Thank you for participating today.
Thank you, Commissioner. I wasn't aware Mr. Trout knew me so well. So just to be clear, we have given the option to use the My OHEP Status website. I understand it's not the preferred option, but it is, in fact, an option. We are beholden to human service articles when it comes to our administration of the program. We have to adhere to a very strict level of privacy concerns and statute when it comes to sharing this information, which I think the retailers would actually find far more cumbersome than simply going out, asking the person if they're on energy assistance. If they say yes, okay, well then we can only offer you a reasonable rate. If they say no, I'm not sure, well, we can double check with My OHEP Status. I don't think this is unreasonable, and I think it really is on the retailer's docket to ensure that they are doing the corrective measures to make sure they're not enrolling our customers into contracts they shouldn't be.
Thank you, Director Molyneux, and thank you for being here today. Actually, at this point, we're going to take a recess. We've been going for an hour and 45 minutes, but when we come back, parties should be prepared to discuss the second threshold issue, and it's with respect to the abrogation or potential abrogation or modification of existing supplier contracts with customers who are on home energy assistance and what happens to those contracts effective July 1st, 2023. So get your arguments ready. We're in recess until noon. We are back on the record. At this point, we will move to another discussion issue with respect to abrogation of any existing supply contracts and whether they should be modified or canceled effective July 1st, 2023. Open to hearing any arguments on that topic. I don't expect the utilities to speak to this topic, but they may, although I know Exelon Utilities did express a concern whether their computer systems could handle keeping track of two sets of supplier contracts. Does anybody wish to speak to this issue? Mr. Wallace.
Good morning again, Chairman, Commissioners. The Retail Energy Supply Association and NRG, kind of briefed this issue pretty extensively in our comments, and we think this is a really kind of core issue for implementing the statute. And when you're interpreting a statute and deciding how to apply it, whether to apply it prospectively or retroactively, there's a pretty well-established body of case law that lays out the framework and how that analysis is done. And really it comes down to the threshold question of what is the statutory intent based on the plain language in the statute. And from our perspective, that's really where the analysis here starts and ends, because the statute specifically allows for, it has prospective language about the restrictions beginning July 1st, 2023, and in subsection B1(2) of the statute, it contemplates that there will be contracts in place that will be up for renewal after that date, and it includes a prohibition on renewal unless the customer is on an approved offer. So the key thing that we really called out in our comments is the language talks about offers, and an offer is a precursor to a contract, and the statute recognizes and distinguishes between contracts and offers and uses both terms. And so, in interpreting the statute and reading the statute as a whole, you see that there is this structure whereby there are, starting in July, there are going to be approved offers and not approved offers. Each of those categories of offers is going to result in contracts, and there are limitations and requirements that apply to both categories of offers and the subsequent contracts. But certainly, with respect to any offer that results in a contract that is in place prior to July 1, 2023, the statute contemplates that those contracts will continue until they are up for renewal, at which point they will have to move in one direction or the other to comply with the law. And so, because that is the threshold step here in interpreting the statute, you don't need to go any further than that. The language of the statute is clear, that it's intended to apply prospectively, and we encourage the Commission to interpret it that way, and we've laid out a framework for that in our comments.
Thank you, Mr. Wallace. You briefed that sufficiently and provided lots of case law here. Thank you. Ms. Rantala?
At the risk of sounding like a broken record, we agree that the law by its express terms applies to supplier offers beginning on July 1st, 2023. So supplier offers made before then and the contracts resulting therefrom were excluded from the reach of it.
Thank you. Anybody else? Mr. Albert.
Thank you, Mr. Chairman. In its comments, staff did agree with what the supplier's position, that we believe that as of the effective date, July 1, 2023, the statute talks about essentially two buckets. It says that cap applies to existing new contracts and renewals of existing contracts, essentially two buckets. Renewal of existing contracts and new contracts going forward, without mentioning I'll call them the pre-existing contracts, those pre-July 2023 contracts. So I appreciate, one argument would be by the suppliers, and they've made it here, that if the legislature did intend to apply this cap to the pre-existing contracts, they would have said something about it. They wouldn't have left it sort of sort of gap there in the language. Having said that, that is staff's position, but we do acknowledge as Ms. Peltier was pointing out, this is a statute that is dealing with the most vulnerable members of our community. This has got a compelling public policy associated with it. It's protecting people's ability to pay their utility bills and be able to continue to get utility service. So we think that, while from the language of the law, if you're just looking at the words, there's grandfathering is suggested of the pre-existing contracts. There's enough ambiguity there, most notably that the law does not specifically address this, that would, the commission might go the other way. I would point to 4308 B3, which talks about if a third-party retail supplier's offer is not approved by the commission, the third-party retail supplier may not charge a customer receiving assistance from an energy program administered by OHEP. So there's want to focus on the language, we see grandfathering. If you want to focus on ambiguity and the purpose of the law, you could go the other way.
Thank you, Mr. Albert. Mr. Fitzgerald.
Thank you. Garrett Fitzgerald, State Climate and Energy Policy Manager with Montgomery County. My comments are very much in line with what we just heard. Our interpretation of Section B3 is that and we readily admit that the language is a bit vague, and that the bulk of the regulation, or the bulk of the legislation, talks about offers. But our read of that section, I believe it's very reasonable to interpret it as applying to any customers who are OHEP, energy assistance households, regardless of when the offer was made. That interpretation would be more inclusive, and it's clear as looking at the legislation itself as consumer protection legislation. We think it's very reasonable to act in a manner that is inclusive of protecting more customers of the same kind that the legislation very explicitly talks about, customers who are on energy assistance programs from OHEP. So we would encourage you to interpret Section 4B3 as indicative that the intent is to protect customers on existing contracts.
Thank you. Anybody else?
Yes, Mr. Chairman. Jacob Alexander with OPC. We didn't brief this issue, but I would agree that the language in B3, Romanet 2 of the statute, in order for that to be given effect, that certainly any contracts entered into after July 1st of 2023 should be subject to either conversion to an approved commission-approved offer, or to have the customer drop back to utility default service.
Thank you. Counsel.
Thank you. Olivia Wine, Staff Attorney at the National Consumer Law Center. And just wanted to say, while we didn't brief this particular issue in our comments, we do agree with Montgomery County and staff's interpretation. There is ambiguity. Our reading of 308B with the third-party retail suppliers may not offer to. We feel that that's clear, that it doesn't put households in a bucket. That there's as Ms. Peltier had pointed to, a very strong public purpose with the amount of overpayment for consumers put on these retail supply contracts. The intent of this legislation is to ensure that those taxpayer dollars are not squandered, but are leveraged as far as they can reach, and so that, protecting those monies and those funds and making sure that those households are not paying more than the standard offer rate is, we believe, the intent of the legislation, and that you have the authority to interpret it that way.
Thank you. At this point, we will begin to review the proposals by all of the parties who submitted specific proposals in subtitles 51, 53, 54, and 59. I do not know whether or not we will get through this rulemaking session today, but we will move forward. To the extent that any parties wish to speak or elaborate, as the document on the screen is being edited, you may approach a podium, or a member at the table may signal me. The commissioners will not be taking individual votes on each of these items. To the extent that a commissioner objects, the commissioners should note their objection on the record. Otherwise, the commission will move forward as we power through these proposals here. So I will turn it over to Ms. Knoll and to Mr. Baker of our staff.
Good afternoon, Chairman. The first edit that we've received is in the definition section. It's an additional kind of group that would qualify as the definition of aggregator. This was not in the straw man. This is an edit from Montgomery County.
If Montgomery County would like to address this edit, I'm not sure this edit is relevant for this proceeding and may be better saved for something coming out of the consumer choice aggregation work group. Mr. Fitzgerald?
Yeah, Garrett Fitzgerald with Montgomery County. That's our feeling as well, because within the definitions we see the word aggregator appear. We thought it might be useful to clarify that aggregator, as it is defined here, does not apply to a community choice aggregator. We do think it's appropriate for the community choice working group to consider issues like this and to bring recommendations forward. We just thought it might be useful to add some clarity in the definitions.
Okay, I would propose that it be removed, but Mr. Fitzgerald, depending on how if my commissioners agree with me, then you could let the CCA work group know of that decision. Does any commissioner object to removing this? Seeing none.
Your Honor, the next edits came from technical staff. The straw man envisioned including in applicant and application the ability for a supplier to apply for approval of an offer for energy assistance households or contract for energy assistance households. Staff prefers to remove this from applicant and application and simply stylize this as the submission of a form, I think is the full edits.
Turn to staff if this is more substance over form, or if there's a reason.
It's in between the two, Chairman. So the applicant and application have definitive meetings that are used in the terms of when a supplier applies to be licensed in the state, and that's basically what this whole COMAR deals with. The tack on at the end, the new section added in these proposed regulations is really about the approval of offers, not of licenses. So we would just be more comfortable not having two definitions for applicant and application for being clean. Throughout these regs. This would result in non-substantive edits later on, but this is more or less ensuring we don't inadvertently add additional burdens to approving an offer that were really supposed to be done during the licensing phase.
Thank you. Any concerns from the bench? Seeing none, we'll adopt staff's position.
Thank you, Your Honor. The next edit is to the straw man had a contract for energy assistance households. There are a number of competing edits here. The first is the question of whether we want to use the term contract or offer throughout the regulations. That'll have conforming edits that happen throughout, depending on how the commission decides that. And then there is also I think, more detailed definition from staff. I don't know which order you want to address those two edits.
So 4-308 uses both terms.
Correct.
Are they different? Are they the same? Are they interchangeable in a statute?
In designing the straw man, the term contract was used simply because contracts are much more concrete and able to be kind of evaluated. So for ease of administration for both, technical staff, commission, suppliers, CAD, the term contract was selected.
And we have staff and we have RESA/SFE with two proposals. Would you like to defend your proposals?
Sure. I have a comment on the contract offer, but I'll first start with our edit. Our edit was simply a clarifying edit about just trying to add in some specificity about the legal requirements. Theoretically, you could also throw in COMAR in there, so it's definitely more style over substance. The other, in terms of contract versus offer, there was a second threshold issue, I guess, or a third threshold issue that we'll have to eventually tackle depending on how we implement this, which is contracts entered into after July 1st, 2023, and it's really the situation of a customer who is enrolled originally with a supplier who was not energy assistance, but then later becomes energy assistance. I believe the suppliers have set up their rule, or their intent would be throughout the proposed regulations, is that those contracts also would continue throughout their entire term. I believe staff's position is based off legislative intent that no, we would end those contracts once the customer becomes, or basically the customer could not be served under those contracts after the fact, because this law, the intent after July 1st, 2023, is that the customer should not be charged more than SOS. So that is a threshold issue that probably might impact the use of the term contract versus offer throughout these regulations. So that might be something we need to discuss.
Will we get to that issue later on in the day's program?
Yes.
We will, and if we make that decision later, we can go back and make conforming edits.
Yeah.
Can we address this issue later when we get to that issue?
Yes,
Okay,
sir.
all right, so we'll take a pass on this one.
So then the only edit the commission needs to consider here is whether the commission prefers the language, which would read, that meets the legal requirements to be offered to customers who are part of an energy assistance household, or if the commission prefers language that would read, that meets the legal requirements of PUA Section 4308 and any other applicable requirements in the Public Utilities article in connection with a supplier's supply services for customers who are part of an energy assistance household.
Ms. Knoll, is this the service address v. household?
Nope.
No.
No, staff's edit effectively outlines where some of those requirements are located, and simply attempts to be as broad as possible in terms of where those requirements could be found.
Thank you. So we're talking about item 8 here, number 8?
Yes. I think we're talking about item 8, and then it's the change associated with comment 6 from staff.
Thank you. For some reason, my comments don't have numbers, but I see number 8. Do commissioners have any concerns with staff's proposal for contract for energy assistance households?
What's it say? I can't see there.
It's
I'm going to just change the color of the font. I think that might help. Oh, no, it stays in red line. I can read it again if you'd like.
Yeah, I see comment MGK4, but I don't see the other two.
So this is MGK6, which is now in red. But the problem is it's red on red.
Oh, okay, I got you.
No, I made some changes.
This morning, oh, good, because I think I'm like, oh my God.
You guys have this in the next section.
Yes, that's what I'm thinking. I've seen
I
it.
know, I just moved it up.
Okay, thank you. No, I just make sure I have.
You go to review. Go under.
okay. Okay. Seeing no objection, the commission adopts staff's proposal.
Thank you. The next area where we have straw proposals and red lines is energy assistance program.
Pardon, Molly?
Yes.
Were we going to touch on the other offer versus contract issue, or is?
I believe the
Did you
chairman
just vote on
suggested
that?
we would resolve that later.
Okay, thank you.
So we will have that conversation eventually. So we are in definition 13 of energy assistance program. The original language staff has suggested adding Maryland ahead of Office of Home Energy Programs. And then in addition, language which states home energy programs by which a customer receives financial assistance paying their electricity or gas bills, which includes but is not limited to, and then it lists several programs. The only item I would flag for the commission is that if we include gas utility bills in the electric section and electric utility bills in the gas section, we may create a problem whereby utilities do not have all the information they need. And I don't know if this is intentional, this was an issue raised by the parties in the filings.
Yeah, so, yeah, we wanted to make it clear because the statute says OHEP programs. It does not specify which OHEP programs, and there's financials associated with those programs, that this is as broad as possible. We were comfortable having a list of known programs, but that shouldn't be limited to simply those, especially if OHEP adds additional ones in the future or something is not caught today. In terms of gas versus electric, that is probably a threshold question in terms of, because once again, the statute doesn't make it clear in terms of do gas utilities need to keep customers who are receiving electric assistance off? So this is comprehensive as saying you're receiving any assistance from OHEP, you can't be on it regardless if it's gas or electric. But I do agree with Ms. Knoll that that would require a process change to make sure if it depends on how we choose to enforce it, but if it is done through the utilities, that is a enforcement issue that we'll have to take up in terms of how that is communicated.
Is there a fix that we could do here to address her concerns?
In terms of, I guess the question is, do we believe that if a customer is receiving gas assistance from OHEP, but not electric, should they be precluded from receiving an electric offer? If we agree with that line of thought, then we have to leave electric and gas in there. We could delete it, but either way, to comply with the law, we would have to check both. So that's the complication, but probably driven by how we view the customer's energy assistance status.
And I would add that there are also customers who receive energy assistance for items that are not on utility bills, such as fuel oil. So if we are making the determination that it's any form of energy assistance, there may actually be a modification to staff's edit that is necessary. The strawman was written to only bar shopping for electric customers receiving electricity assistance and only bar shopping for gas customers receiving gas assistance. In order to minimize the utility burden, PEPCO would not need to know the WGL status of a given customer.
So staff's proposed language fits into which bin?
Staff's proposed language would bar a customer receiving assistance for any form of energy from shopping for any form of energy.
I don't see a better proposal. Again, the legislation did not assist us with respect to customers that may receive assistance for one utility service versus another.
Yeah, and Mr. Chairman, this is a nuance that I don't know that I picked up on initially. Ms. Knoll is correct that there are certain types of energy assistance program that I understand OHEP administers that would fall under the Maryland Energy Assistance Program that would not be for electricity and gas utility bills. The fuel oil was the example. My reading of the statute is that those customers should still be protected. And while OPC did not object to staff's proposed language here, I guess that is, but maybe by adding these words, we are limiting the effect of the statute in a way that wasn't intended by the legislature. And I think that the idea is that there are some households that heat their home with corn pellets or wood. They are eligible for federal heating assistance. That is a program that is an energy assistance program administered by OHEP. We believe that they should be protected, but we overall agree with staff's opinion that those customers should be protected even if they are applying for electricity and they have not received electric utility energy assistance.
Thank you, Mr. Trout.
Mr. Chairman, although this is not directly my issue, it is very much indirectly my issue. First, I agree with staff's and OPC's interpretation of the statute and the need to be expansive in the definition of who is protected. And what then makes this my issue is this will be another gaping hole in addition to the ones that I had identified in my written comments, because we the utilities won't know an electric company isn't going to know if somebody's getting gas assistance or some other form of assistance unless we build a whole new mechanism to track information across all utilities. It's like we won't know if somebody got energy assistance in somebody else's service territory in the prior year, and we won't know if the supply offer that the customer is getting is from a qualified supplier is in fact the qualified offer or not. They're just all of these holes in making us the gatekeepers, and this is yet another one.
Counsel.
Yes, Olivia Wine, National Consumer Law Center. Also, looking just at the language of 4308 B3, the language is pretty broad. It is for receipt of funds from an energy program administered by the Office of Home Energy Programs, or charge a customer receiving assistance from an energy program administered by the Office of Home Energy Programs, and that is broadly written. They could have been more narrow if they wanted to be. So we encourage a broader, expansive interpretation.
Thank you, Ms. Beckham.
Thank you, commissioners. Going with a broader interpretation kind of plays back into our earlier comments here, where the suppliers need to work with OHEP, because as been mentioned, PEPCO will not know about whether a customer is receiving energy assistance for something related to their bill that they receive from WGL. So again, here is where the suppliers really need to communicate with OHEP in this instance, and we can't get in the middle of that because we're just not going to know. Going with that broader interpretation.
What's the fix here, Ms. Beckham?
Well, if you could just say the bucket where gas assistant customers receiving gas assistance only receive the they can only the precluding, keep them in the separate buckets: gas, electricity. But I'm just going to say, if it goes with the broad interpretation, there's that concern, and making it the solution would also be keeping the utilities out of it if the move is to the broader.
Thank you. Mr. Kane.
I'd just like to reiterate what Mr. Trout and Ms. Taylor said. We're the gas company. We don't receive information on any other type of home assistant.
What's the solution then?
The solution, well, I believe the overall solution is to probably either require OHEP to be the agency that informs the suppliers as to who's receiving funds, or either that, or that they provide the utilities with the information, with all the information.
Having OHEP provide WGL regarding their PEPCO customers who are on home energy assistance?
We would prefer that OHEP would be the agent, would be the party that would inform the suppliers as to who's receiving any of their funds anyway. But if the utilities are going to be the ones to police or to be the gatekeepers, then we're going to have this information. I'm not sure offhand how the regulation can be fixed, except for either making OHEP the actual gatekeeper of the information, or providing the information to the utility.
Thank you. Mr. Albert.
Oh, go ahead.
Oh, Ms. Knoll.
I was going to say, if the commission is comfortable keeping it by bucket, electric utilities, no electric shopping for somebody receiving electric assistance, and no gas shopping for somebody receiving gas assistance, simply deleting the or gas here, and then using gas but not electric in the separate sections of the regulations would achieve that.
That's correct, because we are in 51, subtitle 51 right now.
Mr. Chairman, I would agree that would be a fix, but it would not be a fix that would lead to the protections of the statute being implemented. I would suggest that instead of electricity or gas utility bills, to just say paying their energy bills, and then that way and then that still leaves the problem with
That's
how
ambiguous, isn't it?
Well, I think it tracks the word energy program used in the statute, so I think it's consistent with the statute. I think that what is being discussed here is a problem with the implementation and how utilities would find out about the status of a customer. Again, under OPC's view, even though we view the utilities playing an important role, we do not think that they should be subject to liability or all of the parade of horribles that some of the utilities have mentioned. We really just want them to take reasonable steps in implementing screening procedures. One possible solution would be, for there to be, some information provided to eligible households about this prohibition, so that they would learn that if they are receiving fuel oil assistance, that they are protected by this, by this legislation for any supply offers that they receive from an electricity supplier. And I understand that OHEP, generally does a number of outreach events and disseminates information. So that would be an agency that I would imagine, might play a role in disseminating information. But as far as trying to fix the problem in a way that would limit the effect of the statute, I would caution the Commission against doing that.
I think it would be unworkable to add another layer of regulatory burdens and hurdles by requiring now communication standards being placed between WGL and PEPCO or First Energy and whoever supplies gas to those customers. I would support what Ms. Beckham said, keep the bucket separate. In subtitle 51, we would strike gas. In the gas subtitle, we would strike electricity. And that would be my preference, as Ms. Knoll just proposed. Any objections or concerns? Commissioner Bubar.
I agree that is probably not 100% consistent with the intent, but I don't see it workable any other way. So I would go with the proposal.
Just so I'm clear, are we going then with the straw man, or are we just revising the staff proposal?
We're revising the proposal on the panels to simply strike gas in the electric section and electric in the gas section.
Okay. And as far as workability, Mr. Baker, as far as the Commission's reporting requirements, have you contemplated how we would do that if we expanded this interpretation?
I think we're narrowing our we're narrowing staff's interpretation, which is you got, like we were saying, the statute didn't differentiate between the type of energy assistance and a location. I think what we're hearing is operationally, if our solution to enforcement is going to be through the utilities, operationally that's going to be very problematic, because that they don't know about that each other's customers today, right?
And do they know about all these programs?
Well,
all the OHEP programs?
Right, that's the thing. I don't know. They know about the ones that we have listed here for themselves, but like, let's say that a customer is an electric customer who is receiving fuel assistance because they have propane at their house for whatever reason. Like that is an assistance program. How they learn about that, we would have to discuss how to change systems. And to Mr. Trout's point, either we're having an expensive fix, or we're opening a loophole because we're not looking at it.
So you're comfortable with the revised staff?
I don't. It's hard for me to say that I'm comfortable, because I think we do view it as that's expansive. Like the intent was to cover that, but if that's where the commissioners want to go, because operationally it's just going to be unworkable with our solution, I think then that's where we would end up going, right? I think that's a operational fix versus an intent fix. So I think that's intent-wise, we think what we proposed is more in line with the intent, but we understand from an operations perspective that's a pretty hard lift in terms of what we requested here.
Right, since part of the operations is the reporting requirement.
Right. Let me just review the reporting requirements really quick.
Okay.
Again.
And while he's doing that, I just want to mention again that I would caution the Commission against changing this definition in a way that would be inconsistent with the intent of the statute, simply because there might be some some implementation problems. If we kept the definition, even if it was more vague, to cover those situations, it might be that we're unable to know whether it happens, but the protections would still be there, so that if a customer did learn of the program, they could and they articulated that they were covered by the program to their utility or to their supplier, that they would have remedies available to them. So I would just caution against throwing the baby out with the bathwater, which might be the consequence of adding some clarity to this definition. And maybe this would be an example of where ambiguity is actually more, a better approach.
So, Commissioner Richard, to the question about reporting, the real question is how we, when we report to the General Assembly, choose to interpret energy assistance. If our interpretation is broader and we encompass everything, then I think that striking this would be detrimental to that. If our interpretation is energy assistance within the service territory for the utility that serves that service territory, then this definition falls within that. So it's really, how do we want to interpret energy assistance when we report to the General Assembly? So it's an interpretation of energy assistance and how that is encompassed within these rules and within our reporting.
Okay, thank you for that clarification. I appreciate it.
All right.
Commissioner Linton, then Ms. Wine.
Oh, I'm sorry. Maybe she should go before I ask my question.
Ms. Wine.
Maybe she'll answer.
Thank you, Commissioner Linton. Just to piggyback on the reporting requirement, one way you might be able to capture, and it's not perfect, but if you had that propane customer who wanted to transfer, the no early termination fee protection only applies if you're on energy assistance. So if they identify, yes, I want to transfer, I don't want the early termination fee because I'm energy assistance, but somehow they had a problem with that, you would be able to capture that and report that, and that would be a broader definition of people that fall under the protection that you are aware of in the operations of the rule. So it's a bit more passive, but a broader interpretation would allow for that type of collecting of data.
So I actually had a question for OHIP. I know Mr. Baker, he's talking to her, but
You might be asking the same question.
Right, you might be asking her the same question I'm asking. Maybe I'll just ask you.
We're on page 3 of 56.
I wanted to know if for those customers that are receiving, a customer who is receiving a LIHEAP grant for propane, but do not receive an EUSP grant, are they still in the system to show that they're in OHIP, receiving OHIP assistance, that same system that the utilities can access today?
Yes, they are.
Okay. Is there a distinction there that suggests that so that the utility or whoever is looking in there would know that the customer has not received any assistance to pay down their electricity or gas bill?
It's broken out by program, yes.
Okay, so if the utility logs in there, they may just look in a program to see if the customers in that particular section is only receiving a type of assistance.
Correct.
Mr. Khan.
Good afternoon, Commissioners. David Kahn. I'm with BGE. I just wanted to clarify that in the normal course of business, if that customer that you described received OHIP assistance for, let's say, propane, but not for electricity, we, BGE, would not receive any indication, any information about that customer from OHIP. Normal course of business, we wouldn't have any reason to seek out that information, right? And to do that, we would have to probably use the same database that Ms. Molyneux was talking about, which is the MyOHIP status. Again, without any trigger, any reason for us to look for that, we wouldn't have any occasion to do it.
Right, the information wouldn't be proactively sent to you because you're not getting any money from OHIP.
That's right. OHIP sends us and every utility a weekly file that lists all the customers who've been approved for whatever types of grants that customer is getting. If a customer is getting, let's take PEPCO and WGL, it's the easiest. If a customer is getting a gas grant for WGL but not an electric grant for PEPCO, their name's not going to appear on the file that OHIP sends to PEPCO, so PEPCO will have no way of knowing.
Okay, so Ms. Molyneux, how many customers are we talking about, percentage-wise, of the total number of customers that OHIP provides assistance to that would fall into this category that we're talking about?
I'd have to look at those numbers specifically to get you an accurate depiction, but it's going to vary statewide. So certain residential areas are going to see a higher proportion of the caseload looking like that than, say, your Baltimore cities or Baltimore counties.
All right, so, and I guess the final point to this is that even if the consumer is not receiving the electricity grant or excuse me, if the utility is not receiving an electricity or gas grant, but the customer is still getting LIHEAP assistance, they could still get solicited by a supplier. I believe that's true. I don't see anyone responding at all, so.
So your question is, could the supplier still solicit the customer under an energy assistance contract if they're receiving these funds? Like, if we're in PEPCO's service territory, the customer's getting funds from WGL, and they make a solicitation for electric. Is your question, was that a legal solicitation?
Yeah.
I think under our definition, the solicitation with electric and gas in there, our interpretation is they would have to give them the low income offer.
Right.
If we strike gas from the electric and electric from the gas, then no, they would not have to solicit it. But that's then our interpretation of energy assistance is only by energy assistance programs within a utility for the utility itself. That's the narrowing of energy assistance that we have to accept.
Okay. Thank you.
Mr. Trout, we should have put you at the table. If you could be brief, we have a lot to get through today.
Yeah, I understand. I didn't think we were going to get here to this point this quickly. But the argument that has been made repeatedly in favor of using the utilities as the gatekeepers is that we would be able to use existing processes and the utilities already have all of the necessary information. And I tried in my written comments to point out to you several instances where that was not the case, and here's another huge one. And by the way, we have a lot of customers who use propane in our service territory.
Mr. Trout, I agree with you 100%.
You're welcome, Mr. Trout.
If we are not here to produce implementable regs today, I don't know why we're here. I recognize there's various interpretations of the intent. I think the ambiguity of this legislation lends itself to a number of reasonable interpretations. I agree with you entirely, Mr. Auslander, that fuzzing this up a bit and making this energy assistance has some pros, some cons. But my proposal to my colleagues would be in this subtitle 51 to simply strike "or gas." We'll pick up gas in subtitle 54. That's my proposal to move us along. Are there objections?
I just want to point out we're on page 3 of 57.
At the same time, we won't rush things. We want to get this right, but we do have a lot ahead of us today. Commissioner Linton?
Yeah, maybe I was going to say something nice before lunch, though. Or, not saying we were going to lunch yet.
Well, for people who are wondering about lunch, we'll go to lunch in about a half hour at 1:15. Okay. But if you'd like to say something nice, that's...
Oh, absolutely. I was just going to suggest that the gas section has a lot of similarity to the electric section. Yeah. So I know there are 57 pages, but it may not necessarily be that we have to work through all 57 pages, because what we answer in the electric side will apply to the gas side. Not for everything, but for most of it.
For a lot, yeah. We'll move with more speed as we get through this, to the extent there are mirror images of electric and gas, yes. Thank you.
Thank you, Your Honor. So I'm going to record that we're deleting "or gas" here, and I'll make a conforming edit later. So the next definition that we have is energy assistance household.
I'm sorry, excuse me. Before we move on, Chairman, I think you said that you wanted to open it up to a vote on that topic, and I guess maybe just for the record, just have a vote be taken on striking of that word.
We'll only be taking one formal vote at the end to approve or disapprove of this the rules. Although I allowed my colleagues a chance to object, I didn't see any objections. So
maybe perhaps I missed that, but. Just by doing that, we were narrowing some of the protections that are in the statute as well, such as the prohibition on the charging of a termination fee to customers. So I do think that there are benefits that are going to be deprived from customers that maybe are heating their homes with a a less common method in Maryland, and I really just wanted to let OPC's position be known that we are strenuously against that.
OPC's position is on the record. We will do our best to make this an implementable law. However, to the extent that we're trying to find solutions on the edges for folks who heat their house with corn kernels or propane, we're doing our best here. I do not see a law implementable. I don't see regulations that will be implementable to the extent that we are requiring the utilities to layer on yet another expensive inter-utility communications protocol. Your position is noted.
Thank you.
Your Honor, definition number 14 is for energy assistance household. The straw man as proposed defines the household as a service address associated with the utility account qualified for energy assistance during the current or previous fiscal year. There are two issues that have been raised in the edits. The first is whether this should be service address or household, or service address or household. And then the second set of edits from SFE is whether or not we should strike current or previous fiscal year. The reason the straw was written this way was purely based on my understanding of how OHEP and the utilities communicate with each other. OHEP identifies the member of the household who is qualified and then associates that address with a utility service address and then an account number which will receive the assistance. Current or previous fiscal year was based on the statute, which includes requirements for both. No renewals for current recipients, but no termination fees for recipients in the previous year. Again, for implementation reasons, it was simply made more comprehensive to include both of those.
Thank you. Could we have the utilities and the OHEP administrator approach? Ms. Molyneux, we'll start with you. Your records, are they households that receive home energy assistance? Do you track by the household, the members of the household, or by the service address that the household, where they receive the benefits?
Members of the household where they receive the benefit. In fact, our definition does not reference service address in COMAR.
Thank you. The utilities?
Our comment is primarily based off of the definition of fiscal year.
Okay.
Not-
We'll get to that in a second.
Yeah.
Mr. Trout?
So a household, in our records, a household is a service address.
Okay.
So we would prefer service address because we think it's clearer. But if you change it to household, in our system, it will come out the same way.
What is a household?
A household is a group of people living at a particular address.
At an address?
Yeah.
They have to live at the address.
So that's why we track it by the address.
Who's opposed to this, using the service address? OPC, Montgomery County, and NCLC. Mr. Auslander?
Sure. We're not necessarily opposed to having the service address being included, but we do want to point out that households are not, especially under a definition that would look back at the previous fiscal year, somebody could be an energy assistance household, and if you are using their service address as the way to identify them, the service address, if they've moved from one year to another, would not be at the at the address that they had when they were receiving the energy assistance in the previous fiscal year.
Does the new utility know that the household has moved? In your example here.
So I think maybe similar to some of the issues with the previous definition, I think we need to be careful to the extent that we are not just wordsmithing, but we are changing the effect of the law. So I believe that there was a suggestion to do households and or service address, and maybe that is a better way to. And I know that it maybe is not better from a clarity point of view, but to the extent that these definitions are going to have substantive effect and define the legal rights and obligations of the parties that are covered by this statute, I think it's important that we not make the definitions unduly narrow.
Consistent theme today, Mr. Auslander. If the household moves, though, and the service address is still listed as OHEP service address, and somebody who's not on energy assistance moves into that service address, would that service address still be on the do not call list?
Well, and I guess that's another a problem is if it was just simply service address, I'm not, and I guess I'd want to hear from the utilities, but would that mean that when the enrollment comes through at that service address, even though it's a new customer that is not an energy assistance household, but because in the previous fiscal year that service address had an energy assistance household living in it, they would end up being protected by the statute even though they're not covered by the
If
ambit
I
of the
may,
statute.
Your Honor, just for brevity's sake, that's why it's associated with a utility account that was found qualified. In theory, if somebody moves out of their service address and a new person moves in, the utility will provide a new utility account. That may not be accurate for all utilities, but ideally, the address and the account combination should accommodate moves across territories.
Let me ask, and we have some new faces at the podium. If you'd like to speak, if you object to the use of household/service address, can you speak now?
Chairman, we have from Washington Gas, Terry Wall.
Ms. Wall, you object?
Yes, Commissioner, Chairman, yes, I do. We do have, customer does have an account number, and they do have an address, and when the information comes over, we match it up. If the customer is with that address, we have that as the account number. When that customer moves, we do not mark the new customer in it as low income.
Well, I guess what is your objection then to using either term?
Would have to be associated with the account number. When that customer moves, that account number changes. So it would, that actual low income flag would go with that customer if they stay in Maryland and another area in our service territory. It would stay with that customer. However, the premise or the service address would not remain as low income. So it would have to be
And that's what we want, though.
Right. So I don't want the previous year to, if it's the same customer, yes, from the previous year, but not if it's a different customer as it relates to that service address or account number.
Thank you. Mr. Fitzgerald, do you object? No? Okay. Are any other utilities object, aside from Washington Gas? If you could please enter an appearance.
Hi, Commissioners. Lynette Stark, Southern Maryland Electric. We follow the same process. The account number is flagged as low income, and when that service is stopped, the location isn't flagged. If there's money still remaining on the account that's assistance money, we will take it and move it to the new location if the customer stays within our service territory. So when we move it, that flag also goes along with it.
I think an imperfect proposal here is some type of a compromise that includes both service address and household, and parties could read into those terms as they wish. Any objection from my colleagues?
Is your proposal service address / household?
Yes.
Your Honor, I put service address or household.
Or household.
Because I don't know that we have Comar stylistics with.
Yes. Or household. Thank you.
Mr. Chairman.
Mr. Khan.
On behalf of BG, just if I could ask clarification, is it the intent, you're understanding the intent of this proposed change, that we would be in the role of enforcing the laws, kind of we understand it, for the service address, separate in any way from the person who received the OHEP grant? If that's the case, then I guess our concern would be, as stated, the person could move to a different service address within our territory, and we would ensure that the grant follows them for the remainder of the time the grant should be paid out. And then the old service address is no longer an OHEP service address, and any new person who moves in there would be, allowed to get whatever retail supply offer they want.
That's exactly how it should work.
Okay, and so the wording that you're proposing wouldn't sort of lock in the restrictions to the service address, is that correct?
I would hope not.
Thank you.
Your Honor, the second edit in here that needs to be resolved is the proposed deletion of current for kind of the duration of time over which a household is considered to be energy assistance.
I believe this was from Ms.
Rentala.
Rantala. Ms. Rantala, do you wish to defend?
Yes, thank you. And this is also related to the next definition of fiscal year, sort of an interrelated statutory construction. Just in general, the statutory language does not say 2 fiscal years of coverage. So when you insert current or, it creates 2 years of coverage, but it just wasn't in the statutory language. And for our definition of fiscal year, we would support a more non-technical or everyday common usage interpretation to mean the 12 months immediately prior to the customer's enrollment. We think it's easiest for customers to understand and remember that term, and for others to explain it. Dictionary usage of the term fiscal year means any 12-month period. And so if we define it as the 12 months immediately prior to the customer's enrollment, we think this, in terms of implementation, makes sense because solicitations and enrollments happen continuously throughout the year. And defining previous fiscal year, based on that date, a rolling date accommodates that. If the law didn't want to accommodate that, it would have specified dates. But
Did the law mention fiscal year at all?
It says previous fiscal year. It
So the
doesn't
state-
say current or, it says previous fiscal year.
Your Honor, the law
B.
references both
One
both
I.
current recipients and recipients in the prior fiscal year.
That's right.
And the state's fiscal year, Ms. Rantala, starts on July 1st.
I understand there's a state law technical interpretation. I guess we're arguing more in favor of what does an everyday person understand that to mean?
I wish our regs could be so transparent and understanding that people could understand them, but I assure you that nothing in the Code of Maryland regulations lends itself to an easy interpretation.
Yeah, and the statute doesn't say previous 12 months. The statute says fiscal year.
And if I may, Your Honor, the straw man was selected this way because OHEP operates on a 12-month fiscal year basis, and they assign the grants during that 12-month period.
Thank you. Do you, Ms.
Very quick, just
Beck, on the first item, current, the word current?
no. I thought we were moving to the fiscal year.
We haven't yet, but Ms. Rantala pushed us there. So let's address this first
Okay.
issue yet. She proposes to delete the word current, and I do believe that she makes a good argument because there's no reference to 2 years in the law. I would be supportive.
Mr. Chairman, if I may, I think our staff's position is we either need to keep current or we need to adopt Ms. Rontali's interpretation of 12 months because otherwise we open ourselves up to an operational issue of customers during the current fiscal year not being covered by this law, but the customers who were basically there could be a 3-month gap or something, and those customers now aren't protected by this law, which doesn't seem to go with the intent. So because fiscal year was used in the statute, we interpreted it as we need to keep previous because it said previous, but also we need to be, I guess, a little expansive there and cover the extra time that is currently on the books. We recognize, though, SFE's argument about the 12 months, and that is a solution. Our preferred solution, though, is to leave it as current or previous. But if the commission thinks that that's too expansive, then the proposal by SFE would work.
Thank you.
But we don't, yeah.
Commissioner O'Donnell.
We got to get previous fiscal year. We know that.
Yeah.
Yes.
And so we're gonna go back as far back as we need to go to June 30th of the previous fiscal year.
Yes.
And common sense tells us we have to have current people protected. So we need both, I think.
I was sympathetic to SFE's position, but tying the two, and perhaps Ms. Beckham tied the two already, I do think now that we will need to keep current. Although, of course, the law did not intend a 2-year look-back period. Okay, so we will retain current, seeing no objection. With respect to fiscal year, we have 4 proposals on the table. Some of them are more similar than others.
Can I back you up a second? We're going to keep current or previous, right?
Correct.
Correct.
Right, okay. Just clarifying.
With respect to the term fiscal year, various definitions, I think the Commission sees concerns with SFE's proposal. I thought the Exelon proposal, Ms. Beckham, I might save you a minute, is probably the most workable and common sense, which states that fiscal year means 12-month period that begins on July 1st of a calendar year and ends on June 30th of the next calendar year, which dovetails nicely with the state's law. I would propose that to my colleagues.
And I will happily sit down.
Okay.
I've effectuated that change in the document.
I think Commissioner Linton was still
Oh, sorry.
looking.
I thought there was a definition in statute already elsewhere, but it all means the same thing. So if you don't want to reference another area of the statute, then this is fine.
I think it's in the state government article.
Correct.
Yeah, it's elsewhere.
Excellent identified the state procurements and government article.
So we can do either one, I guess, unless we think the state's going to change it in the future, then we'll just make our own. But either works.
The final proposed red line on which there were no competing comments is the definition of standard offer service, which simply references the statutory definition. The majority of these edits will carry over. The next section is in the administrative provisions. OPC provided a new section 10 in the administrative provisions, which largely copy over the requirements of the statute. But I will let OPC speak to the edits and their intention.
Sure. We thought that it would be helpful to have some foundational language from the statute be carried over into COMAR. That is a pattern that has been used in other sections of COMAR, and I do believe that it increases the ease in which the accompanying regulations can be understood, and would eliminate the need for somebody to have a copy of the PUA on hand in order to understand the substantive portions of the statute. We did, I believe, take the language right out of the statute. Any stylistic changes were just to conform to COMAR, but we didn't add anything that wasn't in the statute.
Thank you, Mr. Auslander. Word for word, you moved the statute as a proposal into the reg text, but I understand the ease for perhaps laymen who maybe stumble their way into the COMAR, but why is it necessary to restate the statute in the regulations?
Like I said, I think that without these provisions, somebody would, I guess, have to find in the regulations the reference to the public utilities article, and then look up the statute in order to see the substantive prohibitions that we're trying to implement in other sections of the statute.
I don't feel strongly, but if somebody is making their way through the COMAR, they probably have a copy of the PUA on their desk as well.
So I got a question. There's two section 10s here. One is an additional new section 10 proposed by OPC. And then there's a new section 10 right below it, which is modified by RISA, SFE, and staff.
Yeah, and
The second section 10 is from the straw man with edits. Obviously, we will conform numbering after we're all done.
All right. I just needed to figure out which section I'm talking about.
We're on the first section 10.
in our proposed edits, we made the previous section 10 section 11, and we just thought that it would make more sense to put that sort of foundational statement at the beginning of the rest of the regulations.
Chairman, I think from recent energy's perspective, I don't know that we have an issue with copying over the language, but if we're going to do that, this language doesn't match exactly what's in the statute, so we would just want to make sure that those are aligned to be verbatim.
Oh, so it's not word for word. Did Mr. Auslander try to sneak in something?
Some of it is kind of paraphrased.
Paraphrased, that's not good. If my colleagues agree to including the statute in the regs, the words need to be right. But I would propose not including, for ease of reference, the statute in the regs. I think it sets a bad precedent and will only serve to exponentially increase the size of our books. Thoughts from my colleagues?
I mean, to the extent it's necessary, I don't think we need the whole statute, but I mean, you could put a statement or something. I've seen that done throughout Comar as well. Just a sentence that says something that, I'm not necessarily saying it's necessary, just suggesting that as an alternative.
Commissioner Linton, we did do that in our definition section above.
Just going back to look at.
Yeah, we did. In the legal, we say the legal requirements of 4308 and other legal requirements as necessary, I believe, or something along those lines. So that's a reference there, and we could also consider in the following section adding a sub little I of some sort that says our application will have something on it that you agree to follow those laws as well.
Okay.
So I think we can cover ourselves without having to put it in Comar.
And just to clarify, the changes that we made to this this language we just tracked that we didn't use electricity or gas supplier. We just put electricity supplier because these are the electricity regulations. If you go to the proposal in the gas section, we use gas supplier. So it's a paraphrase that really does not change any of the substantive rules that were included in the statute. It just takes out the section where they're saying or.
Well, there's more than that. Certainly in the first part there, Part A.
Oh, Mr. Wallace, let me stop you there and see if the commissioners, if they support my position, and then we don't have to reach yours. Do commissioners seek to have the statute repeated in the regulation?
I don't think it's necessary.
With Mr. Baker's explanation, would you support having a reference to the specific section of the PUA but not reproduce it?
I think, yeah, so that's in one of our definitions in the license in the section, and then I would also, and then if we wanted additional coverage, I was saying the next section we're about to review, we could ensure on whatever application we put out to suppliers to apply for an offer, one of their signatures, one of their affidavits is saying, I have reviewed and agree to follow the laws of the Maryland Public Service Commission, the PUA, or something along those lines.
I don't think we say that, though.
We don't. I'm saying we could
He's
add it.
suggesting an edit to add that
So
in the
Into the definition.
Yeah, or
in the next section related to the submission of the form to offer.
Okay.
yeah,
Okay.
but that could be in it.
Because we have a definition in 13, under the initial definitions, energy assistance program means.
Yes.
That's what it means.
I don't object to your proposal, Chairman, but I like the suggestion to add this language in the next session.
We could get to that in the next section. Does not appear that my colleagues to my left object, so we'll strike.
Okay. Your Honor, the next section, I doubt we can complete this before lunch, but I think if we do, we've done a great morning's work.
Why don't we recess then for a lunch break? We'll come back at 2 p.m. We're going back on the record. And for the purposes of the record, I would like to acknowledge that our Madam Secretary is Loretta Schofield. Thank you, Ms. Schofield. We will return to the new Section 10. So, Ms. Knoll, thank you.
Thank you, Your Honor. So the new Section 10 that is in here, the majority of these edits are actually related to contract versus offer. So when we resolve that issue, we'll go back and make conforming changes. The first edit in this section is the addition of beginning July 1, 2023. I believe this is to simply indicate that while the regulations may go into effect before that, this will not be available until July 1, 2023. Hearing no objection to that change. And that change has been made throughout. I'll simply note and see if anybody has any concerns with it where it pops up. The next edit here that's a little bit substantive is the change of application versus submission. We handled that earlier when we discussed staff not wanting this in the application section. OPC has added an additional element to what the submission should include. OPC is requesting that a copy of the contract and contract summary form that will be used for sales to energy assistance households is included in the submission. Hearing no objection to that inclusion. The next one is from RISA. This is slightly different from contract versus offer. RISA has, instead of ensuring that the contract will remain below standard offer service, they're saying that the supply price will remain below standard offer service. I'll let them explain kind of the impact of this change.
Mr. Wallace.
Yeah, I think this generally, throughout the comment or this section here, we wanted to clarify offer versus contract, and I'm happy to go into that, or I can just focus on this particular one right now to start. Looking at I think this is really just a clarification that it's the supply price that's in the contract that needs to be benchmarked against the standard offer service rate. So it's really intended to just, I think, be a little bit more precise and capturing what's in the statute.
I was just curious, so the statute uses a supply offer. Why don't we just transfer over and why don't we go to a new term?
Supply offer, I think, would...
It's consistent with the statutory language.
Yeah, I think... So the statute says commit to charging at or below the standard offer service price. I think if you put supply offer here, the supply offer ends once the customer accepts it and you have a contract. Right? So the offer is the precursor to the contract. So that the offer is no longer in place, once the customer is signed up on that.
So 4308B2 says an approved supply offer from a third-party retail supplier shall include a commitment for the entirety of the term of the supply offer to charging at or below the standard offer service rate or gas commodity rate for customers receiving energy assistance.
Yeah.
And my question is, why change the language? What's the difference between the language in the statute and the language you use?
We could use that language as well. It's this language that we had in the reg wasn't phrased that way.
Your Honor, would you prefer, perhaps I think maybe the statutory term there might be charging. So I'm wondering if the edit instead of offer could be, will ensure that the supply charges for energy assistance households remain at or below.
I'm just asking why it's different than the statutory language. Why do we need to change the language is what I'm trying to get an answer to. I'm not advocating for particular language. I'm saying, why did we change it? What necessitated a change to the language from the statutory language?
If I could answer for Mr. Wallace, I think he was trying to say that the offer is extinguished at some point as it converts to the contract. And is that a distinction it's worth discussion? And was that what you were trying to say?
So, yes, that is our position. I don't know that it's germane to this particular subpart 5, though. I think the language in the subpart 5 isn't directly from the statute, but it's paraphrasing the statute. And to the extent that we want to just match what's in the statute says, for the entirety of the term of the offer, the supplier will charge at or below the standard offer service rate. It just seemed like the reason for our edit here was that saying that you will ensure that the offer or that the contract for energy assistance households remains at or below the standard offer service rate. It was really just intended to be a clarification. But
I'm fine. I don't care. I just wondered. It was a simple question, and I was trying to get a simple answer, and just move along, please.
If I may just throw one thing in there, and we'll get to this later on, but my concern about talking about supply prices, marketers, suppliers, often when they're challenged on rates, will make the point that they offer things like the home appliance warranties and the Netflix subscription, and then we can get into a fight over, they'll say we're charging 12 cents, but really only 10 cents is for the electricity. 2 cents of that is going for the Netflix subscription and the home appliance warranty. So I think the contract price eliminates any ambiguity for what the bogey is when you're looking at the supplier's rate.
Yeah, I asked that question earlier, and I was told there's no material part of the extra goodies offer that's material. I think that's the answer I got.
Yeah, we're not intending to achieve that. That's not what we're pushing for here. We just want it to be clear that it's the supply price, inclusive of whatever you may, include in your supply offer. That price is what is indexed to the standard offer service rate.
I'm satisfied, Mr. Chairman. Thank you.
Thank you. I was unclear if staff was satisfied. Staff, Mr. Albert, you were not supportive of supply price.
I think it's clearer to refer to the contract price, again, to avoid any, I appreciate Mr. Wallace's clarification that he and his clients would not go there, but I can certainly see a creative supplier saying, well, we can tease out, since we're offering more than, because that is the supplier's pitch. It's not fair to compare us to SOS because we offer this customized bundle of products. Yeah. So I just think it would be safer there.
What about Ms. Knoll's proposal with respect to ensure that the charges?
I had suggested supply charges would use a word from the statute and maybe be clear. However, I will also note that there is a section later where we define how those charges can be calculated. So we will delineate some of those things later on in the regulations.
Do we use the term supply charges further down?
I believe we use the term rate.
Give me 1 minute.
Rate.
I think that's part of the challenge of these regulations is we interchange terms and we mix them all up based on someone's stylistic want, and it doesn't make it consistent, and it makes it confusing. What did they mean here? What did they mean there? What did they mean here? They use a different term there. And I just think it mucks it all up, but that's just my opinion. That's why I asked what I thought was a simple question, which is why don't we just stick with the statutory language?
Well, originally, contract for energy assistance households is a defined term in what we're doing here. Whether we use contract or offer, we still have open, but the intention in initial drafting was to use a term we had defined.
Later on, we do use the word retail supplier's rate.
Retail supplier's rate. Mr. Wallace, would that be a better substitute for supply prices? Retail supplier rate.
I think that's fine. I mean, the goal was just to be clear and consistent with the statute. So, I mean, generally we try to use the word price for supplier pricing versus regulated utility rates. But I think that folks will understand what is meant in this rule here.
why don't we include retail supplier rates here, and then when we stumble across the next usage of that term, we'll, if necessary, revisit this section.
There was some discussion before lunch about providing additional language here, I believe referencing 4-308.
Yeah.
Mr. Baker?
We could add a subpart 7 that reads a commitment to follow the terms of PUA 4-308.
Any objections? Seeing none.
All right, and we'll make conforming formatting edits to that one. There's a proposal from OPC to add a section 2 here. After review, the commission may approve a supplier's application for energy assistance supply offers subject to any conditions the commission determines appropriate, including a condition that the supplier uniquely identify the offer in such a way as to distinguish the energy assistance supply offer from other supply products the supplier may be offering for sale in Maryland.
Mr. Aslander.
Yes, Mr. Chairman. We had originally proposed this in the draft regulations that we filed along with our petition earlier over the summer. We included this language because we thought that it might be easier if an approved supply offer was somehow uniquely identified by the supplier in their communications to customers, in their communications with utilities, so that utilities would be able to, more easily determine that this was an approved supply offer. We also, I guess, are envisioning that there could be scenarios that the contract that is submitted as part of the supplier's application, raised some questions or concerns on behalf of the commission, and then this would just make clear that the commission isn't just going yay or nay on a supply offer, but that they could impose conditions as part of its approval of a supply contract for energy assistance households.
Mr. Wallace?
I think suppliers that are making these offers would want to be clear in their marketing about the scope of the offer, and I don't have a problem with this language. It does use the term energy assistance supply offer, which is a little bit different than our.
I've never heard that term before.
Yeah, we were using offer for energy assistance households, so there may be some cleanups like that that we want to do if we're going to retain this.
Mr. Auslander, do we use that term energy assistance supply offer anywhere else?
That was probably an inadvertent legacy of the terms that we were using in the language that we filed over the summer. I would agree that it would be more appropriate to track whatever language we decide on for either contract for energy assistance households or offer for energy assistance households.
Offers for energy assistance households makes sense. I don't think we need the after review at the very beginning either. We review everything.
Chairman, may I offer that the second half of that sentence be turned into subpart 8 of the parts above, as it's effectively another condition of the contract. So I view what OPC is doing here is 2 parts: 1, making another condition, but 2, having a catch-all in the future in case we want additional conditions on our form.
Make this Roman 8 as opposed to 2?
Yeah. Well, number 2 will be a catch-all, but the second half of 2 is really a condition.
Let's see how that looks.
And I think maybe this would be a commitment that the supplier will uniquely identify the offer in such a way.
And I don't know, Amal, if you wanted to change, instead of energy assistance supply offer, I think the chairman wanted it to say.
I'm going to wait until we make the
Okay.
offer versus contract determination
Okay,
and then
sure.
do that off the bench.
And maybe we highlight that or something to go back to. Okay.
I have lots of notes about where I'll have to make that change.
Thank you. And for timekeeping purposes today, we'll go until roughly 4 p.m. We'll likely take one break between now and 4. To the extent we don't conclude this rulemaking session today, it'll be continued to a date in the not-too-distant future.
Any objections to how this is currently set up? All right, hearing no concerns. The next section is, so we've now finished with 20.51. Now we're in 20.53. The majority of the edits in this section are going to simply conform to what we did above. I believe there is one term in here which is new, which is standard offer service rate. And there are proposed changes from staff. The straw man simply stated that it was the utility's applicable SOF tariff excluding any out-of-period adjustments. And this was simply for, ease of application for everyone involved. Staff has modified this, that it would exclude any charges, adjustments, riders, or taxes related to distribution rates, and then creating an obligation on the utilities to post and maintain this rate in an easily accessible location on its website. So I'll let staff discuss the impact of this proposal.
And this is section 25 we're on?
Yes, this is section 25.
So when we were all discussing as a group, trying to determine what is the appropriate price, there were a couple issues that came out of it, but there's general consensus. It needs to be easy to understand, easy to find, such that we all know what we're talking about generally. Originally when staff put forward proposals to the group, we had originally actually focused more on the price to compare. And I don't think that's completely inappropriate, but during discussions there was issues with that the price to compare is sometimes a weighted average price, so it's not actually a period price sometimes, or sometimes within the price to compare language there's multiple periods referenced. So staff just thought it would be more appropriate to just use a general idea, which is the general idea of the TARA or the PUA is we want to charge, what we want to compare against is what the customer would pay if they were with the utility and not the supplier. That's our end goal for the comparison. And so that is why we basically wrote the language that we did, which is basically whatever charge they would be paying except for the distribution charges, because that's the net.
What's a given period?
I'm sorry, I'm looking at.
So the given period in the straw proposal was basically selected so that the suppliers could make different period offers. It could be monthly, it could be over a 6-month period. It basically just, because the statutory term is entirety of the contract, it was allowing the supplier to determine what the length of that contract will be and over what period they're going to do those calculations.
Yeah, I guess the way I'm reading this is what the utility is posting on its website. Just not considering the contract length. I'm failing to make the tie between the two. This is just what the utility puts up on the website. Why does the contract length matter? Or offer length? I don't understand.
I think the attempt was, it is almost a certainty that supply contracts will span more than one SOS rate. And so given period basically means we're looking at the SOS rate over the period of the supply contract. It will change, and we accommodate those changes later on when we do the refund analysis. But we couldn't say in a given month. We couldn't because, that's not the same as the billing period for a lot of contracts. So it was just, an attempt to provide some flexibility over the time frame we'd be looking at this.
Yeah, I guess what I'm struggling with is the ambiguity by saying a given period. I mean, you got fluctuations, as I discussed this morning, in the SOS rates all the time.
Yes.
Might make sense just to remove the period. It's just the rate in effect at any one time. And that's also in alignment with the statute, which is the entirety of the term of the contract. You have to be at or below SOS.
So,
Given period, those two words are open to a lot of interpretation. What's that mean?
so then it would read, is the utility rate as approved in the utilities applicable SOS tariff?
Yeah, that's what I would suggest if my colleagues agree. I don't see the utility of a given period unless someone can explain it to me.
So I don't hear any objections to that edit. Are there objections to staff's edit? Or preferences between that and the straw man?
Just one question. Staff added, included taxes related to the distribution rate. Staff, are you just referring to taxes only? Is that last clause?
Yeah, so the we were looking at the various tariffs that people have. I guess the distribution tax is never really listed anywhere, but like BG&E's tariff, they have a gross up in their SOS rates that explicitly are showing like taxes and fees, and so we were just kind of to be explicit there. But once again, it's really the end goal is what are you going to charge an SOS customer?
I just wanted to confirm that the modification there was only with respect to taxes. Thank you.
All right, hearing no concerns, so we will adopt staff's recommendation for the language in this section. So the next section outlines pre-enrollment information. The first change that's been proposed is for Montgomery County. Montgomery County wants to make explicit that consent is required pursuant to the immediate prior regulation, which does require consent, but was not kind of copied here because there are no changes there.
So the prior regulation already requires this?
Correct.
I see.
And is referenced in this edit.
I see no need to then include this language again. And I would propose that we remove it.
Okay. Deleting that edit. RISA, so the straw man proposal provided for energy assistance household status to become part of the pre-enrollment information. RISA, and I will let them argue, RISA has proposed deleting this as something that is not useful to them and would not be a beneficial use of utility dollars to develop this capability. In the straw man proposal, this seemed like a good way to communicate energy assistance household status, but I'll leave it to them as to why it's not.
Yeah, so in our comments in July, we originally included pre-enrollment information as one of the mechanisms to provide energy assistance status. And in our more recent comments, kind of in thinking about the implementation further, the practical reality is that the pre-enrollment information mechanism is not a mechanism that is used generally for residential customers, and it would not be the cost benefit from the supplier's perspective, and likely from the utility's perspective. I'll let them speak for themselves. Would not be there. I mean, there's more efficient ways to get this information to suppliers, like the like the eligible lists, like the energy assistance customer list, providing notification of existing customers that are enrolled. The use of the pre-enrollment mechanism adds another step to the process that takes additional time and has an additional cost to it. And in thinking about implementation overall and the other kind of utility programming changes that are going to need to be made, this is not an efficient screening tool to use for determining whether a customer is an energy assistance household or not. So we recommend, in lieu of this, focusing on other mechanisms.
Thank you, Mr. Wallace. It is on some level ironic that the proposal is to strike the information that we've been discussing, that the utility suppliers, the retail suppliers need, but I understand your argument at the same time. We'll hear from counsel for SFE, and then staff.
In this vein, when I saw that they made that proposal, I took it back, and from our perspective, the identifier would still be helpful. Having it in the pre-enrollment as a flag will help us avoid submitting an enrollment for an ineligible customer. If this is not done, then it does become much more important that we be provided with some other sort of list or identification of the customers in some other manner.
So you just disagree with RISA? Do you agree or disagree with their proposal?
We still think it's useful, but we think the list can also accomplish that purpose.
Thank you. Can I ask, just for curiosity, are you a RISA member?
No, we're not.
That makes more sense. Thank you. Mr. Baker.
Thank you, Mr. Chairman. I think this is the first of our series of operational issues we're about to have to discuss and dive into. So I think keeping it in here or not keeping it in here is really derived from how much are we going to ask the utilities to be the gatekeeper, and we might need to revisit this. But because I think what we're getting into now at this point is how does the supplier determine ahead of time whether a customer is low income or not, and makes reasonable efforts to ascertain that. If we're going to use the utility as truly just a gatekeeper, if we're going to follow the process that's largely laid out in the regs, yes, this is probably a little bit duplicative and can probably be struck under the understanding that today, my understanding when talking to to NRG, and I don't know about others, but I know when I've talked to NRG representatives, they're basically indicating they don't ask for pre-enrollment information until after they enroll a customer. But to me, what this looks like is sort of, we don't want to change our processes, and so if the utilities are going to basically be the gatekeepers, then yeah, their process is still, we'll just enroll a customer, and if they get rejected, they get rejected. If they don't get rejected, they don't get rejected, and so that's effectively our screen. If you require them to use the pre-enrollment information beforehand, well, they're going to have to change their business process, but now we're getting into, we want you to do a screen ahead of time. Now, if the decision to do the screen is through OHEP tools and not the utility tool, that is fine. But that is kind of that's part of my concern with the striking of this, but I also don't want us to be spending unnecessary dollars on something we don't think is going to get used. So that's where I'm trying to draw this distinction is, if we have the utilities basically doing the enrollment screens that are envisioned in the next sections we're going through, this is probably, yes, something that's not a big deal to strike. If we don't have them going through those enrollment screens, then this might be something that we want to keep in there, because this allows the supplier to look up information before they enroll a customer.
And in your experience, at least one large supplier who I believe is not a RISA member says they do not use the pre-enrollment information until after enrollment occurs?
Correct.
Mr. Trout.
All right, so there are three things you can do here. You can have the suppliers get the status, the energy assistance household status, directly from OHEP. You can have them get it from us through a new mechanism, a new list, which is what I think I heard Mr. Wallace saying was their preference, or you can get it from us through an existing mechanism, which is this mechanism. And as you've heard from me previously, our first choice is for them to get the information directly from OHEP and make their own decisions. But if they're going to get it from us, it would be better, by us I mean the utilities obviously, it would be better and less expensive and easier to set up and implement if we use an existing mechanism. And so my proposal would be, unless you're going to well, even if you don't make the decision to take us out of the gatekeeper function, even then, this information would be helpful, potentially helpful to the suppliers, in I guess in being a check on the information they get from OHEP. So, I would recommend leaving it in.
Thank you. So, one utility plus one retail supplier believes the information will be helpful. Staff believes the information would be helpful, but is concerned about the cost RISA would prefer that this come out. Mr. Baker, any idea of the cost?
I don't know the cost. This is simply adding a line item, so I guess I'd have to look to the utilities. It sounds like Mr. Trout is implying this isn't a large lift for his utility, at least.
Good morning.
Mr. Chairman and Commissioners, Leah Gibbons with NRG. I guess the only other point that I wanted to just flag on the pre-enrollment information, the one thing that I don't think it does, and there are some other ops folks in the room that can maybe confirm this, but so on your existing set of customers that you already have, we can't use this transaction to go find out which one of them are assistance customers. So it might be something usable going forward, but I guess then the second piece of that is you're going to have to use it for every single enrollment that you're ever going to submit, right? So it's going to definitely slow down the enrollment process. We have accelerated switch and we have these other goals that we're trying to meet with folks shopping. So I just would flag that as another thing to keep in mind as you think about the efficacy of this as sort of a screening tool.
Thank you, Ms. Gibbons. NRG is not a RISA member?
We are not.
Is there anything changing in number 7 in this section?
No, Your Honor, the comment bubble just attached to a different word than I intended.
Fair enough.
On balance, I would propose that we retain item number 8 and the status. Any objections? Seeing none.
That completes the pre-enrollment information. The next section is transfers of service. So we have a edit for Montgomery County. And again, Commissioner O'Donnell, just for your benefit, I've labeled it X. I will deal with letters and numbering later. Montgomery County proposes language that says each utility shall maintain current and complete data updated no less than once per month regarding households that have been energy assistance households during the current or previous fiscal year. I think this is getting at this idea of customer lists and how they'll be communicated. But I will let Montgomery County discuss if they're still here.
Garrett Fitzgerald with Montgomery County. I want to preface this by just acknowledging that we do not know how OHEP currently transmits data to the utilities, the format, the frequency, etc. This edit is proposed simply to ensure there is some minimum frequency at which the utilities are, if the utilities are in the role of verifiers of who's on energy assistance and enforcing the policy, there needs to be a minimum frequency with which they are updating that data. This, of course, also requires OHEP to be pushing that data. So I think I heard reference earlier to this might happen on a weekly basis or something, which might preclude the need for this altogether. But I think you appreciate the intent of our proposed edit here.
Mr. Fitzgerald, your proposal would create a new obligation for the utility to maintain this data that I do not believe that they currently maintain. Is that your understanding?
Yeah, with the notion that at any point during the year, a customer could enroll into an energy assistance program, the utility, the regulations are ineffective if we end up going 11 months before the utility is aware that that customer has enrolled in energy assistance and is therefore applying that awareness to new offers or existing contracts to ensure that customers are being charged below that level of service. I do not know yet what degree the utilities do track this right now. I can't speak to that personally, but we're concerned that we could end up having long gaps where utilities are unaware of the status of households and therefore will be ineffective at enforcing the regulations as intended.
How often is OHEP going to send information to the utilities?
We're typically sending that on a regular weekly basis. So the way that we're doing it now would be far more compliant than a monthly basis. But then also I leave it to the utility to answer how often they are receiving that data and applying it on their end.
I'm sorry, I'm having a hard time hearing it.
The utility would then need to answer how often they are taking the data we send them and applying it to their systems.
I really wanted to make sure that the periodicity was coming from OHEP would accommodate this proposed requirement. So.
Your Honor, I may make one comment, which is that this actually is not, it says current and complete data, but it does not limit it to for that service territory. So we may want to consider edits if we're going to keep this language.
I do have a lot of concerns with this language, which is shall, so it does create a new obligation. there's no obligation for the utility to sort of share, post, process this data and make sure that it's current and complete, whatever that term means. I suspect Mr. Trout shares my concerns, but Mr. Trout?
I do, Your Honor, and I stood up to make the point that Ms. Knoll made while I was standing up, which is we only know about our customers in our service territory. So if this was an obligation to know about someone who received energy assistance in a different service territory previously, or is receiving energy assistance with respect to gas, and we're the electric company, we would not receive that data, we would not know, and we would not be compliant with this language as written. So I would, we have the information that OHAP sends to us weekly. We process it, perhaps not instantaneously, but within a matter of a few days. So we know who in our service territory on a very up-to-date basis is receiving energy assistance with respect to their electric service. And you don't need this in order, that's already being done, you don't need this in order to effectuate that.
And this is an obligation to maintain. I mean, that's the focus here, to maintain. And I see they're receiving the information weekly from OHEP, it appears. Mr. Khan, do you have anything to add?
Mr. Chairman, I think you made a very good point a few minutes ago, which is if Montgomery County's intention is to ensure that the utilities comply with other parts of these regulations, act on the information about a customer's OHEP status, then I guess we would have to comply with those as they appear. This statement alone doesn't do it, right? But we feel like we have to comply with everything that we're directed to do. And so if you tell us later in these regs, block an enrollment or inform a supplier about a customer's change in status, then we would do that.
Thank you. I would propose to my colleagues that this proposal be rejected. Hearing no objection.
I made edits and it's making it harder to delete. The next edits for section H speak about the utility obligation to reject an enrollment for an OHEP qualified customer from a supplier that does not have a commission approved offer. The strawman proposal simply makes an obligation for the utility to reject the enrollment if the customer is an energy assistance household, as we've defined, and the supplier does not have a commission-approved either contract or offer for energy assistance households. The edits that have been proposed are, A, we create the beginning July 1, 2023, which was not objected to earlier. And then the straw man had used the term at the time of switch, and I believe staff has proposed at the time of enrollment, which is probably much more accurate. And then the last edit that's in this section is the contract versus offer, which we haven't resolved yet.
Ms. Knoll, is there a place further down where we will resolve? Okay.
Yeah, Mr. Baker identified that we'll resolve that when we talk about, yes.
We'll get to that.
We get,
okay.
and I know where it is.
Yeah, thank you. Seeing no objection.
In section I, Montgomery County made a notification that there should be a 2-week time frame for this notification. And SFE raised some lettering. Again, we'll make sure the lettering all stays consistent. But there is no timing element to section I, and I'll leave it to Montgomery County to argue if that's necessary.
Sure, and this comment was in response to a question that was raised within the work group discussions that happened, what a reasonable time frame would be. We suggested 2 weeks, not passionate about the number 2 weeks, but knowing that a lot of these customers are living paycheck to paycheck, that folks are making budgetary decisions. So if they believe they've just signed a contract with a supplier for a substantially lower rate, then, and we know some of these contracts start out at lower rates and end up going to higher rates, right? And that contract was rejected after they signed the paperwork, and it's all kind of happened behind the scenes. it's important that that customer is informed that the contract was rejected. 2 weeks within that same monthly paycheck cycle seems like a reasonable time frame.
Let us hear from the two supplier representatives.
I just wanted to clarify that we had suggested deletion of Section 8, not as a formatting issue, but because,
Where are you? Section 8?
so we're talking about I, and
I.
we had suggested deleting the reference to or Section 8, and Ms. Knoll, I think, had said we did that as a formatting issue, but the reason why we had suggested that was actually because we don't think that those...
Oh, hold on. I'm very confused. Where is it? I don't see any 8.
She's saying H.
8.
Oh, H as in hotel. Okay.
Sorry.
All right. Did you hear 8 as well? Okay. All right. H.
So we had suggested deletion of that phrase or H, not for formatting, but because we don't think that notification is required by the law and exceeds general practice. And so we were actually suggesting not providing that notification.
Mr. Wallace? Any notification required by law? Mr. Fitzgerald wants a 2-week window in which to notify your customers?
You know, I don't think we have a concern with this one. I think if the commission directs suppliers to notify customers when an enrollment is rejected, that suppliers can, I think that's a reasonable requirement, and 2 weeks seems like a reasonable amount of time. And I would think that, I think most commonly we would see this kind of notice come via email in the modern market. So assuming that the method of notification is, that's acceptable. I don't think we have a position on this one.
I asked SFE come back up. So the current regs require notification for G, right?
Right,
Above.
which is the reference to SCB.
Right. But you're saying that H is somehow not
So this would be
legal?
this would be an entirely new notice that we would have to provide that we don't see a basis in the statutory text for it. I am a little concerned about the suggestion that 2 weeks would be sufficient time to do that.
Well, let's just stick with the substance first before we get to 2 weeks.
Sure.
If in G, a utility shall reject a customer's enrollment in SCB at the time of the switch, the customer has a regulated arrearage, is on a payment arrangement plan, or has applied for or is receiving OHEP funds, right? So I don't understand your substantive argument that there's no basis. I mean, we can put in these regs if it makes sense, consistent with the G rejections, what we do here in H. I don't comprehend your argument.
I understand the distinction you're making. I guess I think I'm talking about something slightly different, just that the statutory language itself doesn't say
understand that.
thou shalt provide the notice. That's essentially what we're saying.
I understand that, but we can go beyond the statutory language. We have the authority to do that. We've already established that. Right?
Sure, certainly.
Okay.
I guess I would just say, the timing of 2 weeks may be ambitious, and if you would give us flexibility into how we would be able to provide the notice.
Understood on the 2 weeks. I thought maybe you were arguing we didn't have the authority to stick this in Comar. And then I would beg to differ with you.
I would say it is incumbent on retail suppliers to communicate any action with their customers. Particularly, I would say SFE Energy Maryland Incorporated, which, sad to say, is, and this is a matter of public record on our website, the worst performing retail supplier in our state in terms of numbers of publicly available enrollment disputes. Bar none, head and shoulders above the rest. I think SFE still has a way to go in terms of communications with their customers. And as Mr. Walls stated, emails can be sent out relatively quickly, and I think a 14-day notice period is appropriate. I would propose that the commission adopt Montgomery County's proposal here. Seeing no objection.
Thank you, Your Honor. Section K is for customers who start to receive energy assistance while receiving service from electricity supplier. So I think this is actually where we're going to have to squarely address the contract versus offer issue.
I think this is also where we're going to have to address is the utility, the gatekeeper. I mean, that was kind of a little bit dressed in H, but that is arguably the minimum required by the statute as rejecting an enrollment. So at this point, as of July, this is starting to get into what do you do with a customer after July 1st, 2023, who enters into a contract with a supplier and then later becomes energy assistance. Does the customer basically get moved off of that contract, and then who should be responsible for effectuating such change?
So just to be clear, staff has provided an edit here that specifies this is contract signed on or after July 1, 2023. So this actually sidesteps the grandfathering of existing contracts issue. So I just want to make clear that we are not talking about contracts that pre-exist the effective date of the statute. So the hypothetical that you all are facing here is a customer who signs a contract on July 2nd, and then on August 1st, they are newly qualified for OHEP. They've never been on OHEP before, not previous year, but they are suddenly newly qualified for OHEP. What happens to that contract? And how do utilities handle that interaction? So there are several proposals here. There are implementation concerns, there are interpretation concerns. The way the straw man was written was that the utility would receive the OHEP qualification, they would communicate that to the supplier, and then the supplier would have a certain amount of time to communicate with the customer and reacquire customer consent to either keep them on a commission-approved offer, or if that was not available, drop the customer immediately. It was raised in filings that that's not something the utilities can accommodate. And then there was also an alternative proposal from RISA, which instead of immediately ending the existing contract and either dropping the customer or moving them to an approved offer, RISA's proposal would instead allow the supplier to finish out that contract, despite the contract having been entered into after the effective date of this statute. And then there is a third alternative, Section K. I'm sorry, I'm losing track of my numbers here. OPC also provided a Section K, which is perhaps a little simpler for everyone to implement. So this is perhaps the meatiest thing we've hit today. So I will defer to the chairman as to which order you want to resolve these issues. It may be easiest to start with kind of the commission's intention regarding the straw man versus RISA. Does the commission intend to allow contracts entered after July 1 to finish once a customer goes onto OHEP, or does the commission interpret the statute as immediately ending those contracts after the effective date of the statute? And I would welcome any parties if I've presented their positions wrong or inadequately.
Ms. Knoll, you started by referencing that the beginning of Section K starts with contracts signed on or after January 1st. Does the straw effectively, though, abrogate or modify those contracts that cross over July 1st?
The intention of the straw, and as I believe appropriately clarified by staff, no, this is for after the effective date of the statute. This does not deal with the abrogation of contracts that existed prior to July 1 issue.
The way I read the statute, I could be wrong, but it says beginning July 1st, unless the commission has approved the supply offer of this section. subsection A of this section, a third-party retail supplier may not offer. So it's silent on the existing contract thing. They can't offer a new one, right?
Correct. But if you continue to B3, if the offer is not approved by the commission, the third-party supplier may not receive funds from an energy assistance program or charge a customer receiving energy assistance.
Right.
So the question is when that customer begins receiving energy assistance, can they continue to be served under that contract that was entered into after the effective date of the statute? And in the straw man, this works a little bit in conjunction with the later minimum contract requirements, where there were edits to include those prohibitions in all contracts in the state going forward.
Since you pointed that language out, I believe that we should not allow the contracts to continue after someone goes on to assistance.
Resun and OPC.
Yeah, thank you. So, RISA and NRG's position on this issue is to follow the kind of structure that was adopted in Pennsylvania, which I think is consistent with the language in the statute. So beginning July 1, 2023, a supplier may not offer to provide service or renew a contract. But this wouldn't be a situation where a supplier would be offering that. They would have signed up a customer that's not. I'm sorry, and importantly, sign up or renew a contract with an energy assistance household. That's not what they're doing. They're enrolling a customer that's not an energy assistance household yet. And the statute contemplates that then they wouldn't be able to renew that contract, but it doesn't say that contracts are invalidated the moment a customer enrolls in energy assistance. And in fact, in subpart C, it says that OHEP may allocate funding towards supplier charges as part of arrearage assistance for contracts that preceded a customer's application for energy assistance from OHEP. So, looking at the structure as a whole, where we have these two new buckets of contracts, approved offers, contracts resulting from approved offers versus contracts resulting from unapproved offers, starting July 1st, this is a situation where the customer is enrolling into a valid contract based on their eligibility criteria at the time, and subsequently they are changing their status such that they can no longer renew, but nothing in the statute says that contract should be canceled. That's not how it's done in Pennsylvania, and we think that when you look at the language in the statute, kind of recognizing that there's going to be these customers and they're going to be eligible to have some relief from arrearage through OHEP, as part of the overall context here, our position is that those contracts should follow the same methodology as pre-existing contracts, where you're completing the term, and then at that point you have a trigger point for eligibility or non-eligibility.
Mr. Auslander, you have a simpler proposal probably for all parties. Can you explain?
Yeah, sure. And for the record, we actually would not oppose the straw proposal that is currently first here. This first proposal, okay, that is a lot more wordy, with the inclusion of the suggested staff edit that customers be essentially re-rated to the SOS price for any 15 or 21 day period where the supplier is attempting to sign the customer up on an approved supply contract.
Mr. Auslander, just 1 second. Which alternative K are you?
We are alternative section K.
Alternative section K at the bottom there.
Yes, and this was actually part of our proposal over the summer. One of the key differences is that it's a much shorter period of time. It would be 3 days under this. It'd either be immediate or within 3 days under our proposal. We did provide an opportunity for suppliers to have essentially have an approved supply offer on hand and have language in their contracts that would allow them to convert those customers over. And we did note a concern with the proposal to have a 15 or 21 day period, where all these customers would essentially be approached again by the supplier and attempted to be enrolled on an approved supply contract. I think we would be comfortable with that if the Section K as amended included this Section E in purple that would re-rate those customers. Essentially, what has been proposed here in the initial Section K, the one that precedes our alternative Section K, is an acceptable solution to OPC, provided that it be included as worded. And touching on the argument about the interpretation of 4-308, we agree that the operative language in B3, Romanets 1 and 2, would lead to the conclusion that contracts that are entered into after July 1st, 2023 should be canceled, because otherwise there would be situations where suppliers are charging energy assistance households on approved contracts, on contracts that are not approved by the Commission, and importantly, that do not include those protections, such as a guarantee that the rate charge would not exceed the utilities default rate for the entirety of the term of the contract.
Thank you. Mr. Auslander, 1A, should there be an or at the end of 1A?
There is at the end of B, so we just, I guess there should, we're saying that they should do A or B or C.
A or, okay, so there should be an or at the end of A.
No, there's an or after B.
Yeah, typically when
okay,
you only need to do it once.
Do it once. Okay, that's constructive. That's
Yeah.
the rules. That's the rules. Okay.
Mr. Auslander, how do you respond to Mr. Wallace's assertion that C anticipates contracts continuing?
I think that it actually anticipates a situation where the customer has their contract either canceled and they switch back to SOS, or they're switched to an approved supply offer, but they in the preceding period, when they were not an energy assistance household, they were lawfully charged supplier charges, and they built up an arrearage on their account. So they would be eligible for the arrearage retirement assistance available through OHEP to include those charges, even though those charges could not have been lawfully imposed on the customer after their application was approved for energy assistance by OHEP.
Staff counsel agree with that?
Well, I think our view is we've looked at this one, and this again seems to be getting the fact, again, you now be transitioned to financial assistance, and this simply says you can get protection for that prior period before you transitioned over.
Okay.
And then this isn't a legal argument as much as just a policy thing. I would point out in supplier consolidated billing, there were concerns that actually staff had originally opposed putting in enrollment requirements for customers to be on the program, but it was determined that it was okay to do so, and so we put in the 3 parameters that we discussed earlier. And as part of that, there was another part to it which we said, and at a later date, this is after the customer signed a contract for SCB, if it's determined you're low income, we're going to drop you from SCB onto UCB or SOS, depending on what the supplier does with you. So, I mean, from a policy perspective, I think you kind of have a little bit, maybe the lawyers would weigh in differently, but I think you have a little bit of flexibility here to say, I want to treat these grouping of customers differently on the choice programs. You're not precluding them from choice. You're precluding them from a specific aspect of choice, as we did in SCB, and that's after the fact of them being with SCB. So this is, we know ahead of time what we're doing here, And we can also put into the minimum contracting requirements, and actually I think it's in our proposed regulations, that all contracts going forward need to have a clause in it that says if at a later date you become energy assistants, that may cause your contract to be changed, and we could modify that language accordingly. So that, I guess we could talk about the law, but we could also just think policy-wise. We've done a similar action in supplier consolidated billing previously.
May I respond to that briefly? I think a key difference between this and SCB is that with SCB you have a customer that is transitioning from one billing option to a different billing option. What this contemplates is canceling a contract with a supplier altogether, which I think is a key distinction between the SCB scenario where a customer is switching back and forth between billing options under a contract but still has a valid contract with that supplier, and this mechanism which would effectively come in and cancel the contract that the customer validly entered into previously.
I would make one final point. This is based on the grandfathering, the first topic we covered at July 2023. So we think now, again, we're talking about the post-effective date contracts. We think it's real important if that customer, I'll call them a transition customer, they transition to energy assistance, that they then immediately, or I think we talk about a 15 business day transition period, receive the benefit of the price cap law. That's the whole point. I mean, as has been pointed out repeatedly, that the law has a broad remedial purpose here. Suppliers are on notice that this can happen, so they can factor this in like any other risk. They know that there's a portion of their contracts that all of a sudden can have a cap trigger, and that again is essential given the volatility of people's financial circumstances. Having that cap, it could be a 12-month contract, and if they transition on the first day of it, or it could be a 2-year contract. Under what Reese is saying, that if you freeze that contract remains in effect till the end of that fixed term. And we think that really does serious damage to the remedial purpose of protecting customers from excessive rates.
I tend to agree with you. SFE.
I initially came forward because I wanted to note that we had proposed alternative language in this section as well, but I believe that Reese's proposed language is getting to the same result, and I think it may be more eloquently stated. So for purposes of streamlining the discussions here, I would say we support the Reese language, and we also believe that 4-308C specifically contemplates this issue. I guess I would like to pick up on the idea about risk, and it will create more risk, and it's not just the risk that you would have of serving the energy assistance customer, but now it's spread over your whole customer base, that at any moment you may lose them, and so that may result in higher prices, or suppliers can't do business in Maryland anymore, which makes the markets less competitive. So that's one of the negative consequences of doing that.
I'd just like to point out that Section C does not say that OHEP can allocate bill payment assistance for contracts that preceded customer's application for energy assistance, which it would need to say in order for that interpretation to be correct.
Thank you.
So we can cut down the number of competing red lines if we determine, are we going to allow contracts after July 1 to continue, or if we're going to end those contracts if a customer goes into energy assistance. That'll cut half the red lines off of our plate.
Staff counsel was persuasive to me, Mr. Chairman.
And Mr. Albert, in your argument, you were aligning with the OPC position.
I think that's right. Yes, that it's essential for the purpose of this law that once you transition to energy assistance status, the price cap law applies.
There were compelling arguments, and again, it's open to interpretation here. Some believe 4308B3 is more clear than others, but I would support, in this case, the OPC proposal.
May I have clarity? Is that alternative section K? Is that the OPC proposal?
No, ma'am, that's SFE's proposal.
No, the second alternative, but is OPC's alternative section K?
Yes, and I
'Cause
believe
you had said something about some purple language, and I just wanted to make sure we were looking at the whole proposal.
so. Yes, so you are not currently looking at the whole proposal. OPC's language would integrate with some of both the straw man and staff's edits. So if we're confirmed, and I believe there are 3 votes in favor of OPC and staff's, and I see a 4th nod and a 5th nod, then we can eliminate this SFE language, and then, whoopsies, oh, that's no good. Then we can look at basically the straw man, staff's edits, and OPC's language. So OPC's language would replace this rather complicated straw man proposal that had a utility notification to the supplier then with the customer. The problem in the straw man is that the utilities are not able to receive a second enrollment notice, which the straw man would require. So OPC's proposal is much more simple, and what OPC has argued is that they would like to include this edit from staff, which I've just highlighted, which is that during the time period between the notification and whatever change happens, the customer will be protected from any overcharges. Accurate?
So OPC and actually Exelon also had a proposal that I would think is similar to where OPC is at. I don't know how much more similar, but I believe it is in the same vein as if the customer, if we determine you're low income, we just drop you. The supplier has a low income. If the supplier wants to re-enroll you, at that point under a low income offer, they can do so, and that is effectively. That's how I read Exelon's comments, and that's sort of what I'm seeing out of Mr. Auslander's OPC's proposal. Staff was trying to work within the bounds of what was originally put forward, and that was effectively we would, if the supplier has an offer, so once again, we're now adding if statements in here, which is going to add some complications. If the supplier has the ability to make an offer to the customer, then we would give them time to do so. And then if they were able to do it within a reasonable time period, they would then change the customer's bill method with the utility. So I don't know if it'd really be an enrollment, it'd really be more of a change in bill method, or not, that'd be some sort of change. I don't know how that would be effectuated through EDI and XML, but there would be a change there. And then staff proposed, because there's effectively, under the timelines that were proposed, about a month, where customers could be charged at the higher rate. And we said, well, during that period, they should be at the lower of SOS or whatever the rate was to protect them from that, because they are now considered low income, and so trying to adhere to the spirit of the law. Staff likes that proposal mostly because it's trying, from a customer service perspective, we're not having a drop, like basically a bunch of flip-flopping, but we do see the appeal of the simpler proposals from Exelon and OPC. But from a customer experience, we thought that the first proposal was ideal in that sense, that the customer is not going to be dropped and then have to have a conversation. It would just be the supplier gets the notice, they go and talk to the customer, and then they make a decision, versus you're changed and then the supplier has to come and have a conversation and then re-enroll you. So there's multiple touch points there. But it is more complicated.
And I would defer to the utilities, but the way I understand the section K that OPC has proposed is all of the obligations here are on the supplier. The utility doesn't have to, the utility sends the notification, and then the supplier handles, they either change what they're charging the customer, they acquire their own consent with their own records of it. The utility does not need to know anything other than did they drop or not. And I do not believe that K would require any significant changes to the utility systems, as OPC has proposed it.
Ms. Beckham.
I think Molly just summarized it pretty well, but the only fine point I would put on there is that we're proposing an automatic drop back to SOS, and I don't know if I heard that in the discussion, but I won't take more time to elaborate.
Thank you. Mr. Auslander, is it not an automatic drop under the OPC proposal?
As we've presented it here, it would not be an automatic drop. There would be up to 3 days that the supplier would have to convert the contract to a commission-approved energy assistance contract. However, I do think that the suggestion that there be an automatic drop at some point, either as in the initial straw proposal or doing it automatically at the beginning and requiring the supplier to re-enroll on an approved contract within 3 days, would also be acceptable to OPC and could be an easier way to implement it.
Ms. Beckham,
No,
anything?
I just heard what I needed to hear. Thank you.
Okay.
And the 3 days, and then if we don't hear from you, we do an automatic drop is how we're doing it in supplier consolidated billing as well.
If I may, though, I believe the utility's concern was that they don't have any ability to receive another notification. Once a customer's in their system on a given supplier, there's nothing the supplier can communicate at that point to indicate they've acquired customer consent again. So if we wanted to implement the utility approach, it would be when a utility determines that a supplier's existing customer is newly identified as OHEP, utility shall within 3 business days provide the solid notice of that determination. And then at this point, the two would simply be the utility will automatically drop the customer, full stop. And then the supplier handles everything on their side again. They get the customer, they get the consent, and then they re-enroll. But effectively, from the utility's point of view, they drop that customer, they're done. And then if they have an approved offer and they contact the customer and they acquire their consent, they can resubmit an enrollment, but the utility has nothing to do with that.
Thank you. Mr. Trout?
So for many of the reasons that Ms. Knoll just explained, if I'm understanding how the OPC modified staff and Exelon proposals all mesh together, this is a lot easier for the utilities to implement than some of the other parts of this, and easier than some of the things that I was thinking we were going to be required to do. But I want to ask one more question. Supplier has been approved for qualified offers. Supplier has enrolled the customer. Customer then becomes low income. What would the utility do when the customer enrolls as low income? Would we drop them even if the supplier has in fact enrolled them in an approved offer? Because then that was another question I raised in my written comments. Then we the utility, by doing that, are disrupting the customer receiving the benefit of that commission-approved offer until the supplier can restore it. And if everybody's okay with that, the suppliers, the customers, the commission, everybody's okay with us disrupting that, and nobody's going to come after us, the utilities, and say we've violated some regulation or have some liability to the customer as a result of that, okay, we can live with that. But I would think it would be better if we're not disrupting the relationship, a valid relationship in the first place. So there's just one more layer of complexity to this than even the really well thought out combined comments of staff and OPC and Exelon would lead us to. And I'm at the risk of channeling Marcus Porcius Cato, and therefore Carthage should be destroyed, and therefore we should not be the gatekeepers.
If I may, Your Honor, Mr. Trout is correct that Exelon's approach would potentially end contracts that were approved, and that, so for example, a supplier starting July 1 could include a contract clause that says, if you enroll in OHEB subsequent to the date of this contract, we will automatically charge you less than SOS. That could be something the commission approves. That could be something that suppliers put as default in all of their contracts. If we take Exelon's approach and we automatically drop customers, we will interfere with those contracts, which would have been compliant under the law. The utilities will have no way of knowing. Alternatively, OPC's approach puts it on the supplier to determine whether or not that is a clause that is in their contract and whether or not they can continue serving, and then puts the liability on them as to whether or not they're contracted properly.
But it also, we would put I think you would recommend putting a reasonable amount of time on them to make contact back to the utility, right?
I do not know that we need to have the utility in the middle of that. Once the utility makes the notification to the supplier, they've executed their obligations. If the supplier doesn't act properly after that, the utility has no role there. Under OPC's proposal.
And if I
Mr.
may,
Wallace?
I think at the end of the day, from the supplier's perspective, the utility should not be stepping in and canceling contracts, right? So I think we're more in alignment with OPC and kind of the framework that Ms. Knoll just put forward, where the utilities are notifying suppliers, and then the suppliers are, they know what the terms of their contracts are. They have the obligation to submit the notice or submit the drop transaction to the utility or transition customers to a valid contract at that time. So really I think that there is a role for the utility to play in providing the information to the suppliers and putting the mechanism in place so that when a new enrollment comes forward for an energy assistance customer, that's flagged appropriately and doesn't go through. But to take it to the next level and have the utilities go in and cancel contracts for suppliers, I think that's a step too far. So we'd recommend that we take that step back and say, notify the supplier, then the supplier will comply with the requirements. In the framework that we're talking about now, that means notifying the customer and then transitioning them or dropping them. 3 business days is tight. I think a little bit more time. Staff originally had 15 days, but having a little bit of a longer period there to facilitate communications with customers. If somebody's on vacation, they just lost out on their approved offer potentially.
Did OPC change it from 15 to 3?
Well, we didn't change it from 15 to 3. We the language that I've included here is what we filed over the summer, so there was no 15 or 21-day period. We just included our original proposal that had the 3 days.
The straw man did include a 15-day
So-
for them to reacquire the customer consent.
I think the distinction here is the original K above says supplier. The customer is no longer eligible for is an energy assistance customer now. You are eligible to provide them the low income. We don't know what your contract says. We're going to give you X amount of time, 15 days, 20 days, to go and make the change. If we don't hear from you at the end of that period, then we are going to effectuate a drop on the customer. I believe what Ms. Knoll is discussing is a modification to what is in OPC's proposal on alternative section K, which would effectively just say after the utility provides notice, there would never be another subsequent follow-up from the utility. So basically the two choices are we give the supplier notice and then we drop the customer if we don't hear from them after a while, or we just give them notice, but if we never hear from them, we just continue on as normal. And if the commission receives a complaint at a later date, or I don't know how somehow we discover that the customer should have been moved, then enforcement action is taken at that time. I think staff is a little more comfortable with the one where we have a certainty of a change at some point, but I do understand the appeal of number 2, which is we just give them notice and then step away.
I tend to support Ms. Knoll's proposal here. And we have the commissioners, I believe, on record.
But, I'm sorry, Your Honor, just to be very clear, when you say Ms. Knoll's proposal,
The proposal you described.
which would be, I actually don't know what my proposal is.
I guess I thought your proposal was to amend OPC's proposal. Is that?
So my understanding of OPC's position was the alternative section K, which is on the screen, but including staff's price protection for the interim period.
Well,
And that was what OPC endorsed, right?
so I think that what I actually endorsed was that if our alternative Section K was not adopted and the commission went forward with the initial Section K here, that we would support that as well with the inclusion of staff's provision here re-rating the contract. So I think that there's less of a need for the re-rate to occur in our alternative Section K proposal because we would be talking about a 3-day period. However, I do agree with the sentiment from Mr. Baker that including a provision that says if the utility does not hear back after a certain period of time that they process a drop might be preferable to a system that would allow a unlawful contract to move forward and then just subject that supplier to enforcement action. We would prefer to avoid that outcome and would rather there be some certainty that the contract that was not approved by the commission is no longer being charged to that customer.
That requires the utility to take one more
That would
action.
require the utility to take an action.
So if we're looking to adopt OPC's alternative Section K, we would then need to provide additional edits to create the utility obligation to drop. And then we've returned back around to where Exelon's concern was, once they have a customer on supply, they do not have an EDI transaction structure that will allow the supplier to then communicate any information about how they're continuing to serve that customer.
So I tend to agree with Mr. Wallace on this point, and I said it earlier this morning, we should not have utilities breaking the contracts of suppliers. I think that's a mistake, Mr. Chairman. I just don't think the utilities should be breaking other companies' contracts. They should notify them, and they should break their, per our requirement, sever their own contract. But to have one company sever another company's contract, I think is dangerous territory.
So that is effectively what OPC's alternative Section K is on the screen.
I did not read it that way.
There's a termination, immediate termination.
Correct, but the immediate termination is from the supplier.
Okay.
So what this does is upon notification, the supplier will either submit termination if they know they can't serve that customer anymore, not the utility, the supplier will immediately terminate.
Right.
Or the supplier will, in terms of their own contract, continue to serve the customer, or the supplier will acquire consent and then continue to serve. So
Right.
that's,
So it's not the utility
correct.
breaking the contract of a supplier with their customer.
And that is the alternative Section K that is on the screen.
And Commissioner O'Donnell, I think there were some remarks that this is similar to a rule that we have in a supply consolidated billing. I guess there's also a similar rule in dropped requests under COMAR, whereby if a customer is required to request that a supplier drop them, but if no drop request has been submitted from the supplier to the utility within 3 days, then the utility can go and process that drop and does not require any further input from the supplier. So if that type of rule is being contemplated here, that would be an improvement over what OPC has proposed in its text, to have there be a role that the utility is playing. And I'm not sure that I would necessarily view it as the utility canceling the contract. The utility is notifying the supplier that there's this legal obligation that they have to comply with within a time certain. And if they do not comply within the time certain, then the utility...
Providing notice.
Right.
And it says the supplier shall end the contract.
And that is how we had worded it, and we think that would be the default option, the preferable way to do it.
By the argument here, right?
I
Which
think
section K are we talking about?
The alternative Section K that is on the screen
Right, it
is...
says that the supplier will terminate the contract.
Correct, Your
But
Honor.
I thought you said that the utility was going to do it. You said that's exactly what that says.
No, Your Honor. The retail supply, so the alternative Section K does not put any obligations on the utility to break any contracts in what is on the screen. The straw man proposal did have that. So if the commission does not want the utility enacting that, then the straw man is the wrong approach, and OPC's approach would keep the supplier in the driver's seat.
And I think we have 5 votes for the OPC approach.
Great.
The only thing I'd just say from what I just heard was after not having heard from the supplier after 3 days, the utility would then process that drop. I think that's not what the utilities are advocating for, because we're not going to terminate the contract. We do want all of that to be on the supplier. So I just want to clear that up too. But other than that, everything that we're discussing, I think, is in line with what Exelon's proposed.
Yeah, and the language on the screen, to be clear, does not require the utilities to automatically do any drops. And I'm seeing nods that
And
that is the intent.
And before we move on, one kind of question that I have in looking at this, it says immediately in A. In C it says 3 days. I think having something like 3 business days for both would be a short window of time, but also give suppliers if you get this notification at the end of the day on a Friday, just to give some sense of how do you comply with this, right? What does immediately mean?
Yeah, if you move the within 3 days up into section 1 and then delete immediately, that would accomplish what Mr. Wallace is getting at. So the supplier would have 3 days to do A, B, or C.
OPC supports that.
I would support that. As I do, I guess, want to be on record saying that this approach that would not have a utility fail-safe, if you will, involved, I think will most likely lead to the commission needing to take enforcement action against suppliers in the future for violating this, because notice is going to be transmitted, and I imagine that it's very possible that a supplier is not going to act on it. They're going to continue to serve the customer in violation of 4-308, and I would hope that the commission would take very strong action against a supplier that does that.
But isn't it an obligation of the utility to report those drops to us on a regular basis per these regs?
Well, if the utility is not processing a drop, I guess they could report to you the notices that they send out, and then maybe the outcome of what the notices that they sent out. But if no drop was submitted by the supplier under what OPC has here in Alternative K, the utility wouldn't be able to report a drop.
So I don't think anybody should be under any illusions that we're not going to hold suppliers' feet to the fire. We've proven that with regard to adherence to our regulations.
Sure.
So that's not a concern for me.
Well,
If they're not following the law, we're going to hammer them.
Sure, and there have been statements made today by utilities and by suppliers trying to ascertain what liabilities they will have and what penalties they might be subject to. And I just wanted to caution that if there is no utility fail-safe in this circumstance, the likely outcome for a violation is going to be an enforcement action.
So be it. That's the case for all our regulations and all laws.
So if I may, I've made a couple edits here to keep up with where we are. So we retain the straw man for 1, which is the utility has an obligation to notify the supplier of the OHEP enrollment. I've moved OPC's 2, which is the supplier's obligation to act, up into this section. And then we could then retain a utility fail-safe for suppliers that we know do not have commission-approved offers. It's a bit of a compromise position where we're combining the two. Or
How would
we
the
could,
utility know that?
So staff has proposed to, because this is an issue that came up in the group, because it's also it's something that we would have to do anyways for the previous grouping H that we went through, is we have to make sure the utilities are aware of who has authorization to be providing these offers and who don't. So staff has started talking with some of our folks on the 16th floor about how we would keep them informed, whether it be through the utility website or through the choice website or through other mechanisms. We've also discussed sending emails, but that would effectively have to be a commission effort to keep the utilities informed of who has authorization and who does not.
Yeah, I don't think the commission should take that obligation on. The suppliers and utilities have the obligations here.
so in that case, we would delete the 3 that is on the screen, and we would simply have 1 and then OPC's 2.
I do think, though, then that does raise issues for grouping H above, though.
You're correct. 3A, which is an obligation to send some cancellation notices, we would incorporate.
No, I mean, if you scroll back up, sorry.
Sorry, that's okay.
This one, part of the enrollment in terms of the gatekeeping. The supplier, if the supplier does not have a commission-approved offer for energy assistance households, that gatekeeping is an issue, or that's a weak point that I'm sure Mr. Trout would raise in terms of how are we being kept abreast of that. And so I think we just have to figure out how we're going to keep the utilities informed to enforce that part of it. Staff has proposed that being a staff or commission function, but if the commission's not comfortable with that, then we would have to go to the drawing board in terms of how we would make sure the utilities know about it, or we're basically informing the parties that they have to find a way to communicate with each other about this without the commission being involved.
If I may, that obligation was not in the straw man and perhaps does not need to be resolved today.
So we're going to approve their plans, right? So they're going to know we approve their plans.
Right.
Correct.
So why do they need to have some special notification?
I'll let the utilities weigh in on that, because I mean I've pushed back a little bit on providing this kind of stuff in the past.
So why wouldn't we just, I mean, the suppliers right now have to upload a number of pieces of information to the commission's website.
Right.
And we could just add another column that says for those suppliers with approved offer, they can just upload that information to the website.
To the MD Choice website.
Yeah, so they don't have to put the rates and everything up there, but
Right.
I guess they
all
could.
we need is
but
something
it'd
that
just be an extra.
the supplier has the ability to do so.
Yeah,
That's
it's an
all we
extra
need to
column.
get communicated.
Yeah, it's an extra column and it's up there. It's public. Everybody who wants to see it can see it.
Right. And that's what we were in discussions with, how we could do that through a website.
Yeah, well, but I guess the point is it doesn't have to be a letter or email or something from the commission, staff, or anybody. It would just be the supplier's obligation to provide that information along with everything else.
Okay. Yeah,
And-
I would prefer that too. Then the supplier has to take all the actions, and that would be preferable.
So would that require a change to the language, or is that an obligation they already?
That would be an obligation that they would have. We would have to have something. I don't know how the suppliers have an obligation today to keep up-to-date rates on the MD Choice website.
Yeah, that's,
So
I'm
we,
sorry, go ahead.
so we would have to make sure, however that obligation is imposed, that we communicate that to all the suppliers, that anytime you have a change in your ability to provide this, you're uploading it to that website.
I think it's another section in Comar that has the list of items that they're supposed to upload. But
Okay.
I think. But
Okay, then we just have to find that.
Yeah.
Okay.
All right.
I apologize, Your Honor. I just want to close the loop on utility drops for suppliers with unapproved. I will delete section 3 if the commission does not want to put any obligation on the utilities to basically, terminate contracts unilaterally.
Okay.
Is that, I see 3 nods and a shrug. Okay. I'm going to delete this section, so then, at that point, we have effectively created an obligation for the utility to notify the third-party supplier, and then it is on the third-party supplier to figure out what's going on in their own contracts, what they do and don't have approved, and whether or not they can keep charging the customer. And then there will be enforcement actions for those who don't comply. I do see a line, so I will hand control back to the chairman.
Thank you. Ms. Knoll, under 2, I think it should probably state 3 business days, within 3 business days.
Thank you.
And Mr. Chairman, I wonder on that point, could we extend that to 5 business days? I mean, that there's going to be an operational implementation that's going to need to happen here. And my understanding is that on the back end, the supplier is going to be, making the customer whole for whatever that transition period is, right? So it shouldn't make a difference to the customer on the timing here. It will help suppliers be able to effectuate these transactions, and they're going to have to take the information in, process it, figure out the path.
I hear you. Objections from the table?
So I don't have objections to the 5 days, but I do believe that we currently don't have the re-rate language. Okay, good. As long as we're adding it back in, then I think that would be fine with OPC.
Mr. Albert?
We're fine with that.
Commissioners? 5? No, okay. No, Mr. Wallace, you've earned your pay today, 5 days.
Thank you.
Ms. Knoll will make the conforming edit. We will not be finishing this rulemaking today, so there will be time, because I recognize there's lots of movement, and Ms. Knoll and Mr. Baker are doing their best to make sure we're not losing things between the cracks, but with so many alternative section Ks and We had the Exelon Section K, that wasn't even the third alternative. Having a few days to digest before concluding, I think, is appropriate. Ms. Peltier.
Commissioners, if I just want to share that the reason this law was so debated in Annapolis is so that it was automatic. And it was exactly what you guys just decided. It's the opposite of what you just decided. If I heard it correctly, a supplier's going to get a notification that one of their contracts is an OHEP customer, and it's on the supplier to drop them. And I just want to share that Pennsylvania was brought up a lot, and I put in my notes the docket explaining that the suppliers are not dropping them in Pennsylvania. There are many issues with that. So this is compliant on the suppliers to drop them, and then it's compliant on customers and advocates to then find an OHEP customer on a supplier, send it into CAD, and have it done that way with no repercussions written in the law. It just seems it's exactly what the law didn't want, for this to be compliant on the supplier to take the action. So I think that is I don't see how that even gets enforced. That you could have 30, 40,000 drops by 50 different suppliers, and somehow a low-income customer is going to even know about this, get their information in, do a whole CAD thing, wait, and there's nothing written in here other than a promise that there's going to be enforcement. I think our low-income customers just deserve one more step of assuredness for the next couple decades, however long this goes on, that what if there's 100 suppliers? How on earth, how are we going to maintain that?
Can I ask you a question?
Yes.
Utilities effectively compete with suppliers through SOS, effectively. And you have one of those competitors canceling the contract of another competitor. How is that even possible? I don't know. You know, everybody's focused on the law breaking, if you will, my term, of the third-party suppliers. Well, what if the utility starts dropping a whole bunch of their effective competitors' customers?
What I'm suggesting is that just instead of just an open-ended, that they're going to get some kind of notification that they're just supposed to drop them, that the commission puts in something more reasonable and logical to be able to go back and say, did this work?
Well,
so I think that's fair.
I can tell you this, that if they don't drop them, the civil penalty we can stick on them for not dropping them is up to $10,000 a day. Okay, so that's pretty significant. So you say there's no enforcement action written in this, but every day they're not in compliance with COMAR, we can fine them $10,000 a day. And we've done that.
But up in Pennsylvania, this is exactly, we looked at all the data up in Pennsylvania, and it's not working. There's an entire docket, and PPL did all this research saying there's still lots of cap customers, they call them up there, still on these high rates. All I'm asking is there could some time be spent on something reasonable to track this. Or it's just going to be a bunch of advocates out there looking at low-income bills and OHEP certifiers noticing, oh, there's another case. This was very contentious. This went from a bill of a full ban.
I know, but you can't speak for the legislature. I was in the legislature for
I
21 and a
understand
half
that.
years. Anyone that purports to speak for the legislature.
Okay, I just for the record then, leaving this up to suppliers to cancel their own contracts is very problematic.
We hear your opinion.
Thank you.
And Ms. Peltier, I would only add to what Commissioner O'Donnell just said. We do have enforcement authorities. We do have penalties. We have revoked the licenses of suppliers to do business in Maryland. I'm not as familiar as to what is occurring in Pennsylvania now. But to the extent, after this these regulations go into effect and the law fully takes effect on July 1st of next year, I could assure you that this commission will not hesitate through its compliance and enforcement unit to take action. And yes, we do have several hundreds of electric and gas suppliers in the state, and we probably can't detect every violation at once, but we have cops on the beat, and I believe RISA and their members and all the other retail suppliers are fully aware of the authority of this commission. Ms. Wine.
Thank you. Two points. One, just really quickly, do support the concerns raised by some members at the table and Ms. Peltier about not having a firm backstop. I think the concern here is how long an energy assistance household could be improperly on one of these contracts before it's found. So I'm wondering if, second point, there could be some reporting requirements. So perhaps when the utility informs the supplier, you've got an energy assistance household, and that's the end of their duty, but to report that also to OPC and to the commission, or, that requirement, at least in the beginning, will help ensure that there's timely enforcement, because it can show or elevate patterns fairly quickly, so staff will know where to look first. You can look and see if does that supplier even have approved energy assistance contract, and go from there. So just encouraging tools be built in, because I think this could be very problematic.
Thank you, Ms. Wine. At this point, I don't, not speaking for the commission, I'm not sure what we would do if the utilities provided the PSC with names and account numbers. OPC, would you want that information?
Well, I think that the suggestion that that we address this potential gap through reporting actually has some merit. When we haven't gotten to this section yet, we probably won't get there today, but we have suggested some reporting metrics that utilities would be required to submit to the commission, and some corresponding ones for suppliers as well. And I think we could include a metric that would report the number of notices that a supplier was sent, and then that information, I guess, could be double checked against the number of drops or conversions that the supplier processed. I think that our office, especially in the early stages of this, the go live date of these regulations, we probably would be interested in seeing that data. We certainly would want to make sure that any gaps that exist in the regulation aren't leading to situations where customers are being served on offers that have not been approved by the commission as required by the law.
Mr. Khan?
Just a quick question for clarification, if I could. Is it OPC's intent that this alternative section K should apply to both sets of suppliers, those with an approved commission offer and those without?
I think the answer is yes, because this would be for customers that were not on energy assistance at the time of that they had been enrolled. So they were just a run-of-the-mill residential customer served by a retail supplier. But then at some point they start receiving energy assistance. Mm-hmm. The utility receives notice, and then their obligation would be, as set out here, to provide notice to the supplier of that fact within 3 business days.
Right, and I think the scenario you laid out could envision a non-OHEP customer being in contract with either type of supplier, one with an approved offer from the commission and one without, and then things change, right, because that customer gets energy assistance. So if I'm hearing you right, I think this section would apply to both types of suppliers. That is, the utility should do the very same thing when a customer with a supplier becomes OHEP, becomes energy assistance, and that is notify the supplier.
That's how I understand this as well, yes.
Thank you.
So in terms of information that's shared with the commission, at least for a portion of the year, the utility companies, when they're attempting to disconnect service, they provide certain information to the commission in advance of the service denial. There's the winter restriction information. There's a number of pieces of information that come with that, along with the status of the customer, are they low income or not? And that's provided, of course, by the utility companies to the commission. So it would require a piece of IT work, but that information could include a question of just a checkbox, yes or no, does the customer have a supplier? It would only get it during a certain portion of the year, but at least it would help during the winter period. We'd know if a customer facing service denial is potentially with a supplier and is low income. So at least for a portion of the time when customers could be facing service denial, it's a piece of information we have.
I think Commissioner Linton, yeah, I mean, we could make that change. We might also just, since it looks like we're gonna have extra time, we should maybe, since this is where we're gonna be going, it looks like what we're gonna do after the fact enforcement, we should just come up with the list of data we think we'll need to review to determine if such things are happening and who's doing it. And then we can either do that via order or via regs, what we need collected from the utilities to make that determination.
And as far as the suggestion to build on existing processes, that always makes a lot of sense. There is a section of 4-308 that requires a report to be prepared by the commission, and we've suggested some regulations that would require the information that the commission would need to complete that report be submitted by utilities and suppliers. And I think that seems like where it would make the most sense to include the reporting of this information as well, because it's all related to the implementation and enforcement of 4-308. Certainly, I think Ms. Wine's suggestion is a possible solution that may address some of the concerns about customers continuing to be served on unapproved contracts.
Ms. Knoll, where does this leave us at 3:50 p.m.?
So I think we've settled that section, and that brings us to the residential customer protections portion of our regulation. I think there are a number of red lines in here which may be dealt with rather quickly. I don't think we can handle another thorny issue, but maybe see as far as we can get before we get to one of those.
Let's see where we get in the next 10 minutes.
Okay, so the straw proposal in O2 adds energy assistance household status as something that the supplier may not disclose without the customer's consent. I see a couple of nods. This next one, again, we're back to that contract versus offer discussion. And perhaps if we could resolve just that one issue, does the commission want to use the term offer throughout the regulations or contract? That would actually help us bring you guys a much cleaner red line the next time we sit down together. So I will say that based on all the discussions we've had today, I think Commissioner O'Donnell is absolutely correct that we should be consistent with language throughout. So I think we need to pick one. Based on all the conversations today, I'm not sure if there's a significant difference between contract and offer. An offer will become the terms of any contract that is entered into. Suppliers are all required to have contracts in order to serve Maryland customers. In every situation, both of things will have to happen in order for a customer to be served. So I leave it to the commission on this one.
I thought you said no more thorny issues.
Yeah, I changed my mind.
Commissioner Bubar.
We had an earlier discussion where we talked about using the term contract based on Exelon's or PHI's proposal. It seems like it's cleaner to use contract, so that would be where I'd be leaning. Unfortunately, the legislation goes back and forth, but I would be comfortable with going with contract.
I support the terminology contract.
I see a nod from Commissioner Linton and a shrug. Okay, so that was easier than expected. We'll make conforming edits throughout on that one.
I gave up trying to get consistency with the language.
Point 05C, which is unauthorized enrollment or service. There's an edit from RISA that this should be beginning July 1, 2023. This is another one that we've accepted before. The supplier may not, and this says offer as opposed to charge an energy assistance household for supply services unless those charges are for a commission approved, and we'll use contract here, for energy assistance households as set forth in COMAR. So this is just adding some specificity.
I would, staff would recommend that the statement offered to be struck, since we've determined that the contract cannot, it doesn't matter if, basically after July 1st, 2021, at any point you become energy assistance, at that point in time, we're not going to allow that contract to, we're going to basically treat them as an energy assistance household. That contract's terms are not going to apply to the customer.
Yeah, OPC would like to see that language struck as well.
I want to make sure that I'm understanding where we're moving here. Has the commission made a decision about the grandfathering of existing contracts?
We have not.
Okay, because that's a key piece of this contract versus offer discussion. The statute says that the commission is going to be approving offers, and that kind of flows throughout. And here's an important example. If you're going to say that beginning July 1st, 2023, a supplier may not charge an energy assistance household, I mean, yes, with respect to new contracts, right? But the reason we added the word offer to there is because that's what it says in the statute, where it says that you may not offer to provide electricity, renew a contract, or charge a termination fee, or charge a customer receiving energy assistance. But all of that is in connection with offers. So I think this is one of the sections where the distinction between offer and contract really comes into force when you're looking at how you're treating contracts that are in place prior to July 1st that carry past that date and would come up for renewal after July 1st.
So I've proposed an edit here that would be for contracts entered into after July 1, 2023. I think that might resolve this concern.
I think it does. Mr. Wallace, does it for you?
I think it does.
Okay, so
Thank you, Ms. Knoll.
I'm going to delete.
Though I just would add, I don't want to, I'm concerned that we're foreclosing the ultimate decision by the commissioners on whether we grandfather what I call the pre-existing contracts. So my concern might be going down that road with some of these regulations sort of decides that issue in effect. So I do wonder if we should reserve judgment. I realize we're not taking final action today or anything, but I would just point that out.
Noted. The commission has not had that conversation yet.
The next section that has red lines and edits is permitted advertising. In section 3, a supplier may not market an offer to energy assistance households unless the offer is associated with a commission-approved contract for energy assistance households. And then a supplier must make reasonable efforts to determine whether a customer lives in an energy assistance household during solicitations.
Question?
Yeah.
How is the commission going to approve the contract? So we're not going to approve each contract, right? We're going to approve the offer or the contract generally.
Yes, there will be a submission of the supplier explaining what they're going to do, and that's what the commission will approve.
So I just got tripped up on the literal reading of that, a commission-approved contract.
Well, so yes.
I understand the broader context, but that language, do we need to tweak that language somehow to make it clear that we're not approving contracts?
We could switch it to offer, but we had established the language earlier that a contract for energy assistance households is what the commission will review and approve.
Generally. Yes.
Generally, yes.
Okay.
And we have that in the definition.
All right.
Ms. Knoll, whose proposal is the red text in 3?
So the red text in 3 that is not highlighted is the straw man proposal. The text that has the pink behind it are suggested edits. RISA and SFE have suggested deleting 3 and 3A. Meanwhile, staff has proposed adding 2 additional sections. And the staff sections would add 2 requirements. One, that general marketing materials must state whether the offer is applicable to energy assistance households. This actually works in conjunction with an edit that OPC made earlier, that these offers must be specifically identified. And then staff has created an obligation that all solicitations to energy assistance households, including door-to-door sales, must be recorded.
Okay, so staff created 3B and 4?
Correct.
And RISA and SFE want to remove 3 and 3A.
And I would assume they would
3B.
want to delete B and 4 as well.
Is that true, Mr. Wallace?
I think, certainly, I'd like to talk about 3 and 3A, but generally,
And this will be the last topic of the day.
Correct.
yeah, subpart B, I think disclosing it when you're setting an offer to energy assistance households, describing the offer, I don't think we would have a problem with that. I think, the challenge here is that suppliers don't know whether a household is energy assistance or not. Right? So if you're doing a general mailer, let's say, and it is for an energy assistance offer, suppliers don't have any way of knowing who to send it to. Likewise, a prohibition on marketing to energy assistance households when you don't know who they are is problematic. So this we want to make this implementation work, and we're trying to figure out a structure that where we can carry out the goals of the statute efficiently and effectively. But the concern here is that there are requirements that are being imposed on suppliers with regards to their marketing activity where they don't have the ability to conform because they don't have the information to know which customers are on energy assistance or not.
I think we've heard that argument loud and clear. What about 4?
So with respect to 4, again, you're not going to know before you're talking to the customer. You're not going to know whether they are an energy assistance customer or not, and even while you're talking to them, you may not find out. So I think 4 is problematic. In a door-to-door sales setting, for example, we've been looking internally to see if there are, if it's feasible to record all door-to-door sales. This is not being done anywhere, and it invokes some serious concerns in terms of, privacy, consent requirements to recording all in-person interactions. It's a big deal, and would be a whole new process and be a whole new can of worms to implement this. And so, and when you layer on top of that we don't know who these customers are, it's you can't just develop a process specific to certain marketing to certain customers because you don't know whether you're marketing to that customer or not, perhaps until the back end when you go to submit an enrollment. So, this section is just rife with challenges because functionally it's not feasible given where we are today.
Thank you. SFE.
Thank just to reiterate, we won't know in advance of the sale whether the customer is an energy assistance recipient. So in order to comply, that would effectively require us to record every solicitation, which would be very costly to implement. And as he suggested,
With what, like a tape recorder, a video recorder? How would you record your interactions? Like a camera?
well, that's the other issue is Maryland's a two-party consent state for audio communications, so that's a complicating factor as to how we would be able to do that.
Thank you. This will be our last vote of the day. Did Mr. Albert have a?
Yeah, so I'll start off and then I'll turn it over to Mr. Mosier. So, in General 3, we do believe the law does require some form of marketing prohibition or something. The supplier has to take some sort of action to make good faith to only be making offers and marketing to the low income customers, the low income offer. Now, generally, when we talked as a group, like everyone agreed it was not feasible really to do to really preclude mass marketing, and also even door to when you're doing your phone calls, it's going to be kind of hard to know ahead of time on some of this. And so really what the point of this is saying is you need to make some good faith attempts to ascertain from the customer, are you low income or not during the sale. General marketing materials would just simply be when you're doing your mass mailers, one of the suggestions that came up in the group was why don't we have some disclosures on it that indicate if the offer is for low income or not for low income. Basically just trying to make it so that we're trying to comply really with the part of the law that's saying we may not make offers to. So that's where we're getting this marketing, I won't say prohibition, but there has to be some sort of action in your marketing world to make efforts in the low income front. As for number 4, I will turn that over to Mr. Mosier as to why we made that proposal.
Good afternoon, Kevin Mosier on behalf of staff. Yeah, this is just essentially, what we're envisioning it possibly in the future. Someone files a complaint with CAD. The supplier states, "Oh, we asked this this customer if they were on energy assistance. They said they weren't." Well, essentially, it's he said, she said. We would like these things to be recorded so that the commission and CAD can know for sure what was said in that interaction.
Mr. Mosier, the representatives from SFE stated that Maryland is a two-party consent state. We still get to pull the tapes from all the telemarketing. Do we have any legal concerns with respect to that? Maybe Mr. Albert?
Well, I'm just thinking we could, when the representative knocks on the doorbell, he says, just want to let you know this is being recorded. I appreciate that concern, but that seems like an easy fix. Also, I switch gears switch gears for a second on this mass marketing. I guess the offer could say, here's the terms of the offer, but if you are an energy assistance household, here would be the offer that would apply to you. This way, the mass marketing could go to everybody, but it would notify a customer that there is there's these additional protections. Just a thought.
I would say that is probably hard to put on a postcard, or if there's an asterisk or footnote on the mailer. Not many people read those. All right, thank you. Anybody else at the table or the room?
Yeah, I just have one comment in response to, the notion that, one of the challenges with doing something like adding recording is, when you start layering this stuff together, it's going to turn into an interaction with customers where the agent is going to come to the door, for example, and have threshold questions of, are you low income? Are you energy assistance? And by the way, do you consent to me recording our discussion today? It puts a lot of upfront additional steps in the process that are going to make for a negative experience for customers. And so, it isn't just that there are technical challenges, but also it's adding in these new things that customers may not want to disclose. Their energy assistance status, and asking customers to consent to be recorded when you approach the door. There's a door-to-door sales act in Maryland that allows that to be done, but something like that may effectively cancel that whole channel out. And it's not just door-to-door. It's what if you are, depending on how something like 4 would be implemented, what if you are selling at at a baseball game or elsewhere? Anytime you have an in-person interaction.
I think we understand that, Mr. Wallace, your concerns here. This is our last item of the day. I'll start. I agree with you. I agree with you on actually all 3, 3A, 3B, and number 4. I think 4 has some merit, but possibly in a more global rulemaking, not just for low-income supply, but for all interactions with the customers. And you probably won't like that, but I would rather take up 4 in a separate rulemaking proceeding with respect to retail supply solicitations. With respect to 3A and 3B, I think you raise a very good point that you don't know who is and who is not an energy assistance household, and it's going to make it very difficult for retail suppliers to market to a general public when they don't know who they could contact and whose door they should not knock on. That's my position. Other commissioners on this point?
I agree.
So are you proposing A, B, and 4 not be included?
I would strike 3,
Oh, all of
3A,
it.
3B, and 4.
If I may, Your Honor, there may be other ways to produce some of these results. So, for example, if Mr. Mosier's concern is a he said, she said situation, we could add, for example, either a TPV or a checkbox in contracts where the customer says, I am or am not an energy assistance status. And then we'd have a writing of what the customer said at the time of solicitation.
We already use TPVs, though, correct?
For telephone sales, yes, and likely suppliers would see that as a best practice fairly quickly. For door-to-door, it's usually a written contract or an emailed contract back and forth. Again, I think we could create an obligation where the supplier has to maybe, for example, acquire, a customer attestation to their energy assistance status or some other obligation like that to solve this problem.
I would be fine with an attestation. I suspect the retail suppliers would be as well. Correct me if I'm wrong. I do recognize this prohibition stems from the statutory language stating that retail suppliers must use quote-unquote reasonable efforts. And I sure hope that retail suppliers will, short of this that we have on the screen here.
Mr. Chairman, I would just say 3A is, I guess, less about knowing if the house is ahead of time, but it's during the sale, doing the check. So kind of going back to some of the utilities' original concerns, that really it's the supplier that should be making the reasonable efforts to know if this customer is eligible for the offer or not. I mean, maybe the contract, as we're discussing it here, that checks that box, but I think that was the intent. That was not really the house ahead of time. That'd be ideal. But that's more of you're ascertaining the information, and we don't want, going back to it, we don't want to just have the utility gatekeeping being the first and final check for all of this. That really was not, that was the risk of what we're setting up here in these rules. I agree, I admit that, but that's just a point I wanted to raise here in terms of something that 3A is accomplishing that might not otherwise happen.
I understand. Thank you, Mr. Baker.
So could we go with keeping just the first sentence in 3 and eliminating A, B, and 4?
Alternatively, this has gone longer than I intended. We can come back with alternative language when we return on this topic.
We were in the midst of a vote, so I'd just like to, if my colleagues would like to share any thoughts now, or we could hold till next Wednesday, which is the date we'll be meeting again.
Well, right now, I think I'm leaning more towards staff just because I believe that's what's required by the statute. We need to do something that has a meaningful effort to have this prohibition on marketing. And I think the language on reasonable efforts does come right from the statute. So, again, I think, well, for me, we may still need to work with this language a little bit. Otherwise, I fear that we will have something that's not compliant with the statute. And I do think that there might be some alternatives to 4. Again, along the lines, I've even in live solicitations, that at the end of the discussion, at the end of the pitch, you do get a third party, make a phone call or something, then they go through those requirements. So it might be a little overly ambitious to expect a recording, a video, but perhaps some kind of an alternative, again, verification that this was an appropriate solicitation. So I guess that's where I am right now, kind of wanting to see if I can work with staff, because for me, I think it's...
I don't know if there's when I was talking about the requirement in terms of vetting offers or who you're talking to, that comes really out of B1. the third party retail supplier may not offer to. That's, I think, where the marketing, I don't think the reasonable efforts is in the statute.
Yeah, I don't see it.
No, it's not.
But yeah, I don't think that was in the statute. But I think that that's trying to strike a balance of saying you gotta get it right versus I tried.
And there was a supplier during some of the stakeholder meetings. I'm not sure if I don't believe he actually submitted comments, but he was asking what what he would be required to do when it came to marketing his offers generally, and what obligation he might have. So I would just suggest that maybe striking it might seem like an easy fix, but there was a like a desire by at least a supplier to know what their obligations were when it came to this sort of activity.
Is there any marketing obligations in the statute? I didn't see any.
In the statute, no. But
Okay, all
what their obligations would, his question was what his obligation would be under these implementing regulations to inquire about a household's energy assistance status.
Thank you. Commissioner Linton, last word.
Sure. I'd like to see some revised language for 3 and A. For 4, I would recommend the parties consider the Door-to-Door Sales Act and some of the county huckster laws that address interactions between a sales representative and a customer at their doorstep or somewhere else within the county jurisdiction. So I think there's merit to it, but I think it needs to be written a little differently.
Thank you, Commissioner. Thank you to all the parties for participating today, for taking the time to file comments, to provide red line. Special thanks to our advisor, Molly Knoll, for creating this compilation document and shepherding some of the conversations today, as well as the support from staff. We will conclude this rulemaking session next week, Wednesday, November 2nd, approximately 10 minutes after the Commission's regular weekly administrative meeting. Before we conclude today, any items that we need to discuss for housekeeping reasons?
Mr. Chairman, would it be possible to continue on Tuesday? I'm going to be on a plane on Wednesday. I just wanted to ask if we could.
I don't believe so, Mr. Wallace.
We have a briefing until 1, and then Your Honor has other meetings.
I'm sorry, Mr. Wallace, we would not be able to accommodate your schedule next Tuesday. It's not the way I typically like to run this hearing room. Would you have anybody that could stand in for you?
I will talk to Mr. Green.
It's always nice to see Mr. Green. Thank you. Thank you. We are adjourned until Wednesday, November 2nd.